You are not interested in that matter.
No, I am always interested.
So you will get a chance in that matter.
Kindly.
Only for that, so that all the matters are touched. Not only for that. Yes. Circuit bench.
Amount has been deposited. I left something, but nothing has been.
And what the circuit bench they can.
And
Hearing, please wait for some time. Some slips are accepted. Let those some matters be disposed of thereafter. Don't mention for the present any matter under the heading hearing for inclusion.
this is also hearing matter, but
Please wait for some time.
difference is there, my lord. Petitioner is retired in the month of December.
I appreciate.
And at the end of service, my lord, he has been terminated. He retired, my lord. Kindly take up.
The writ petition of which year?
It was 2024.
Wait for some time. Yes.
At the end of service, he has been terminated, my lord. At the end of his service.
Mention before the regular bench. Yes. Call the list.
Mentioning for correction.
Correction. Yes. Correction.
Notice within limitation.
When it was dismissed for default?
August 23, 2024, and thereafter within 2 weeks.
Before which bench? Have you served notice upon the other side?
Annexed.
Yes.
My lord, mentioning WPA number 18933 of 2020.
What do you want for hearing inclusion?
Yes, hearing.
Not now. Yes, call the list.
It is out of the list.
Yes.
Item number 1.
Key correction. Huh? Ashun. In the office note dated March 13, 2024, Pustup, the order for correction was the order by an order dated August 31, 2023, the department was directed to carry out the necessary amendments. Pustup, the reasons for carrying out such amendments at a belated stage is accepted. Pustup, it has been pointed out that though the application for substitution was allowed on August 31, 2023, 23, but in the order dated, no, directing, in the order now, directing substitution of Joba Chatterjee in place and stead of Vikas Chatterjee since deceased. In the order dated September 15, 2023, the Costatal read as double inverted comma madhye Vikas Chatterjee versus State of West Bengal and others instead of Joba Chatterjee versus State of West Bengal and others. Let such error be rectified. This order shall form part of the order dated 15th September 2023. এটা কি কবে ডিরেকশন আছে পুটা or disposed of the yes, call the next matter.
Seven.
After your order, first order, they have appeared to keep.
Why it was adjourned?
My lord, last occasion, it is the case of my learned friend that there is an appeal has been preferred against the suit. My lord, colleague, that 5 decibel of land which is
Yes,
subjected.
yes. Oh, what is the fate of the appeal?
Yes.
Appeal is pending. They have appeared. On 30th 11, they have appeared and they have prayed for time to file the objection.
It was initially dismissed for default, subsequently restored.
4th May 2024. Appeal is allowed with section 5. That is pending.
So restoration application has been allowed, now
Allowed.
the appeal is pending.
Appeal is pending. Section 5.
Then, not, I think, appeal till the disposal of the action also.
That I will now consider. Yes.
Now, if your lordship it takes up the opposition reply of the petitioner,
Mr. Rai, what have you prayed for?
demarcation. Apart from that 5 decimal of land which is subject matter acquisition, why, my lord? It is the case of the respondent number 4 and 5, the entire land was acquired in the year 1956-57. Some other substance. Now, if your lordship
Mr. Rai, there are two things. One is plot number 42.
42.
Plot number 42, the extent was more than 5 acres.
Yes.
The total extent. So, in the suit, in the judgmental decree, it was held that you have right title and interest excluding that 5 acres
Yes.
in that plot.
Now 5.05 acres.
Oh,
5 southern.
5 decimals. You have right title and interest over the entire plot excluding that 5 decimals. Now,
The case of
now the documents, from the documents, it appears that the entire plot has been recorded in the name of the.
and they are also claiming to be the owner, it is the entire plot by virtue of
Yes. So there are two things. That whether they can claim or not, that is in violation, you have to thrash out there. Because an appeal is pending. Mr. An appeal
Section
is pending.
5, along with section 5, my lord.
Maybe. Appeal is pending. You can say there is no appeal has not taken its part. Those are the things. If it is, but appeal is along with section 5 is pending. Section 5 is not yet dismissed. So there is an existence of an appeal along with section 5. I stand corrected, not an appeal, along with section 5. Now,
Then limbo.
now during the pendency of that appeal, because whether now you are the owner of the balance portion or you are not the owner of the balance portion, that will be decided in the appeal. Now, whether for the present, leaving aside whether in this case demarcation can be made or not, leaving aside that, whether at this stage can an order for demarcation be passed?
I turn to page 16 of my
Because
reply once, my lord.
page
For the sake of-
16 of the reply.
suggestion and we have the meeting over.
Mr. Bagh, you will get your chance.
If
Kindly
you reply to the opposition of respondent number 4, page 16.
not the report. Not the report. You are on the
Reply. Their report has been said they are claiming to the entire that it is
report and exceptions are there. You are on your affidavit in reply
yes to the opposition respondent number 4,
to the, yes, to the opposition of the respondent number 4, page
16. My lord,
16.
this process is just if the plot of land was acquired in the year sometimes in 57, 58 according to them. Entire plot of land was acquired 42 in its entirety. Then what prompted the government for further acquisition in the year 1989? Same plot.
No, I could not follow.
According to them, the respondent said that in the year 1957, 58, the entire plot number 42,
58.
58 acquisition case. Entire
Where is that? Where is that?
Yes,
in the
brother.
opposition.
in their opposition. Well, can take to their
The
opposition.
opposition of respondent
Now
number 4.
4. Now I am relying upon page, my lord. Page 3, paragraph 5.
Oh. Inter subject land being plot number,
42.
yes.
So according to them, it was done some.
Mr. Rai, that is the subject matter of the suit.
It
Whether
is, my lord, it is a state document. I rely upon it is a requiring for.
appreciate all these, but you can thrash these issues in the appeal. You can take these points in the appeal. When an issue, Mr. Rai, only with regard to what extent has been acquired or not, I am not on the entire part. That is the subject matter of the appeal. Whether they could have acquired the entirety, or if that was acquired in 1950, whether this notification was bad, all these are, because we have challenged that in the suit.
Yes.
All these will be decided in the appeal. So whether at this stage, unless that appeal attains finality, can at the present an order of demarcation be passed? Because
To that
let
extent, my
us
lord,
assume, let us assume that yes, demarcation with regard to this 5 decimals is allowed. Subsequently, let us assume appeal is allowed, says no, you do not have any right, title and interest in respect
Also, sir.
in respect of plot number 42. So this will be an infractuous order, Mr. Rai.
To that, what I am submitting, your lordship, as on this day, my lord, the status of the petition is
But-
standing.
Yes, I follow your argument, but the court, it has been brought to the notice of the
Yes,
court
yes.
that an appeal is pending. What thing I can do? I can give you liberty to raise this point in the appeal also, the issue of
Right.
demarcation.
My lord, issue of demarcation, my lord, at their
Or
appeal.
you can move, I will give you liberty after the appeal is decided.
But till now, my lord, if you logically consider your lordship is granting stay, which they are not in a position to ask before that, because their case is
No,
that-
what stay?
because there is a declaration that
Yes, declaration you have, no stay.
no.
But for
Like,
the present,
if I unable to, my lord, this
Mr. Rai, you are trying to execute that in the form of writ. In a form of, this is what you are trying to do is to execute that decree. Pending an appeal.
my lord, may I,
I follow your argument, there is no stay.
my lord, may I
I follow your argument, there is no stay.
my lord, may I pray with
So
your
there is
lordship,
no
one
part
thing.
to proceed with the
My lord,
execution
can you
also.
keep this writ application out of list? If section 5 rejected, my lord, one thing.
Mr. Rai, I will give you liberty, you file, you will, it will
Once,
be
if your
easier.
lordship can consider, if your lordship directs that till disposal of the, after disposal of the appeal, I have liberty to file this writ application.
No.
Then, my lord, what?
I will not say anything, not disposal, for the present, with liberty to take steps.
What will happen, my lord, where can it be your lordship? Today, if your lordship, either way, dispose of this writ application either way, then, my lord, the appeal is the sole position. So that's why, my lord, if today, tomorrow, my lord, the section 5 application rejected, then, my lord, or they will not take steps, the appeal will continue for a pretty long time.
I will
The-
give you liberty, you can file an application, it will be easier to move a motion rather than an hearing matter.
Then, my lord, record everything, and after that, my lord, that debate will be. record this in entirety because I have to rely upon this judgment.
Yes, yes, yes. The petitioner petitioner or petitioners,
Petition.
many,
Only one petition.
the petitioner, but in the suit there is Balaram Noskor and others,
Yes, there are 6 there, out of which one came before this.
only one.
Lord, may I take leave?
Balaram Noskor is the predecessor who filed the suit.
Beg your pardon.
No, Balaram Noskor. So you are the legal heir of Balaram Noskor.
Yes, Balaram Noskar was originally the plaintiff, one of the plaintiff in the suit,
Yes, yes. Balaram Noskor and others.
and others. The
Who are the
Kanailan
others?
Noskar, Subal Noskar, predecessor Sharat Chandra Noskar,
Bharat Chandra was the original one.
original.
So this Balaram Noskor and others are his heirs.
Yes,
So you are one of the heirs.
one of the years.
The petitioner, along with his brothers and sisters,
Yes, brothers and sisters.
along with his brothers and sisters, petitioner also was one of the plaintiff.
No, at that point, Balaram Noskar was Balaram Noskar was alive.
Yes. So you are
So-
the heir of Balaram.
Yes, sir, Balaram.
All right.
Subject to correction, my lord. আমি দেখে নিচ্ছি
Kindly be sure of that.
No, let
No, you are the heir of Sharath.
I am the
You are saying Sharath was the original owner.
Only one person has come.
That is the decree. Have you annexed the decree?
yes, page 26, my lord. Yes, Balaram Noskar is the plaintiff number 1.
Yes. And you are, what is your name?
Subal. Subal is 3.
3.
Yes, my lord. Beg to be corrected, my lord.
So along with his brothers,
Brothers.
I said so, you said no.
Yes. I have another impression, my lord.
Along with
Sorry,
his
my lord.
brothers
I
and
beg to be
sisters,
corrected.
filed a suit, being title suit number 140 of 1998, before the learned civil judge, Junior Division 6th Court at Alipur, praying for declaration of title and permanent injunction in respect of,
Lord, I am taking leave.
yes, in respect of the property mentioned in the schedule of the plaint of the said suit. The said suit was decreed on contest,
On contest.
was decreed on contest by a judgment and decree dated January 29, 2015. Thereby declaring that the plaintiffs are the owners of the suit land as mentioned in Schedule A of the plaint 7 except 0.005 acres of land lying in the northern portion of Dag number 42, Mauja Gopalpur, Khotiar number 1470 under Police Station Mohestala in the district of 24 Parganas South. The plaintiffs also got a decree for permanent injunction restraining the defendants from disturbing the peaceful possession of the declared suit property by the plaintiffs. Full stop. Where I stopped is also struck you. Full stop. The state of West Bengal,
That 0.005. 0.005.
0.005, কি হলো? As well as the district collectors and the officers of the officers of the requiring body were the defendants at the state of West Bengal, কি
Yes.
বললাম? Collector, comma, first land acquisition collector and the state of West Bengal, তারপর district collector বলেছি তো, তারপরে লিখুন first land acquisition collector and the authorities of the requiring body were party defendants in that suit. Appeal preferred by whom? Requiring body,
Yes, RB.
not the state. It is not in dispute. আচ্ছা না, তার আগে লিখুন the petitioners have filed this writ petition praying for issuance of a mandamus commanding the respondents to demarcate the land of the petitioner, particularly the unacquired land situated on RS tag number 42, on the aforesaid RS tag number 42. Full stop. Mr. Rai Learned Advocate appearing for the petitioner submits that since the title of the petitioner as well as other owners of the said plot have been declared, unless and until the unacquired portion is demarcated, the owners of the land are facing difficulties in possessing the property peacefully.
In view of the record of rights also.
Full stop. Mr. Rai further draws the attention of the court to the recording in the LR record of rights.
LR record of rights.
In the LR, kindly check up that.
Yes, this is the
Recording-
comprehensive LR record.
Recording in the LR record of rights, wherein the entire plot number 42 has been recorded in the name of radio station.
One is BSNL, page 25, subsequently it is radio station.
In
These
the
are
name of-
authorities.
Now, initially in the name of BSNL and subsequently in the name of
Radio
radio
station.
station. Full stop. Mr. Rai submits that such an
That has-
erroneous entry in the record of rights is also creating problem in the peaceful possession of the petitioner in respect of the property in question. Full stop. Insofar as the allegation of the petitioner with regard to erroneous entry in the record of rights is concerned, it will be open to the petitioners to take appropriate steps in accordance with law. Full stop. However, insofar as the prayer for তারপরে লিখুন, it is not in dispute that challenging the said judgment and decree, an appeal has been preferred by the requiring body, being title appeal number,
33 of the 18.
being title appeal number 133 of
2018.
2018. Though the said title appeal stood dismissed for default, but the same has been restored
By order
And-
dated 4/5/2024.
by an order dated
24.
4/5/2024, and the said appeal along with an application under section 5 of the Limitation Act is pending before the learned
Learned district judge in.
before it is still now in before
No,
the
no,
district
it
judge.
cannot be, my lord. So the.
Before the learned dot দিয়ে রেখে দেন তারপর
নাহলে district judge।
তারপর থাকবে না
kindly
ট্রান্সফার
take instructions. Full stop.
ট্রান্সফার হয়ে যাবে সেটাই বলবো। হ্যাঁ,
Uh,
at that relevant point time.
since an appeal is pending, he-
the computers, it was stated. It's stated.
না তার আগে লিখুন the order the relief claimed by the petitioner in this instant writ petition is in effect an attempt to execute the decree passed by the civil court.
Land acquisition
Full
act
stop.
will.
Since an appeal is pending against the said judgment and decree, this court is not inclined to grant such relief at this stage. Full stop. Petitioner will be at liberty to approach the appropriate forum for this will be কি বললাম? Will be at liberty to approach the making it clear appropriate whatever appropriate. Sir, I am not deciding that issue. That is why I have said appropriate forum
Once if you logically,
accordance with law.
once this will,
I have not said this is not the forum. That issue I have not decided. Appropriate forum. You may choose any other forum also. Then if I specify this forum, it will be a problem for you. That is why I have kept it.
they will prepare an appeal, nothing will be there. Be as it may, my lord, one thing I draw your lord's attention.
Before the appropriate forum in accordance with law. Full stop.
My lord was pleased to held that the suit was degreed in a sense, shoot property excluding that portion, my lord, kindly record the schedule. Otherwise, the schedule is mentioned in the degree itself. Otherwise,
No, I could not follow.
yes.
No, I have quoted from the decree itself. No, I have quoted from the
No, A and B schedule properties are there, but not
A and B schedule properties are there.
if your lordship have kindly consider for delineated for the purpose of ourselves, my lord, the A schedule property, the suit was degreed as if it is a 0.05. Last portion is it will,
Oh.
that's why, my lord,
ওই জায়গাটা পড়ুন তো যেখানে বললাম যে ওই by judgment and decree dated the title না 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 তার আগেটা এটা বললাম না decree judgment and decree dated the said suit was decreed on contest by judgment and decree dated January
2015, thereby declaring that the plaintiffs are the owners of the suit lands as mentioned in Schedule A of the plain.
7 except
0.
if your lordship can delineate, it is recorded that the A schedule, B schedule, otherwise, my lord,
issue the plaintiff is there, Mr. Rai.
in the degree itself, my lord, it is there. If your
Plaintiff
lordship,
is there. That is why I have said a schedule of the plain. I have only recorded what is there. So I don't think there will be any dispute with regard to this. With the above observations, the writ petition stands disposed of. Yes, next.
my lord, state can enlighten your lordship what prompted them to issue further acquisition notice.
Has those points in the appeal. I cannot reopen that issue in this writ petition. That is the difficulty. Yes, call the next matter.
You're always invited.
10.
Then contempt. What contempt?
Lord, your lordship's order was challenged before the
Yes,
honorable.
Ms. Alam, why have you violated the order?
If I haven't violated, I've
They have come up in contempt, alleging violation.
come up content.
You have not violated.
No, I haven't, because the appeal was pending. Appeal was disposed of in August, 19th August. Thereafter, we are moving an SLP. It's all gone to the Supreme Court for filing. It hasn't been filed.
For filing.
Yes, it has not been filed as on date, but everything is done. My instructions are everything is, the final draft has gone for filing.
Then I'm directing this matter to
Supreme
go out of the list with liberty to
Let them
mention.
mention it.
So when the appeal court, do you have a copy of that appeal court's order or the date? And the-
19th August 2024.
Lord, more than 3.5 months passed.
Yes, true.
Mr.
Takes
SLP.
time.
Mr. Shaw,
All
there's a
the
provision of section 5 is there. Uh, This is an application alleging violation of the order dated violation of the judgment and order dated
15/5/2023.
May 15.
Yeah.
2023. First up, Ms. Alam Learned Advocate appearing for the alleged contemptor submits that challenging the said judgment and order, an appeal was preferred being MAT number
2154/2023.
and the
One
same
five-
stood dismissed.
Milord, there are two appeals.
That was
And-
filed by the private party.
1571 of
Rather,
2023.
submits that an appeal being MAT number
2154 of 23 and
preferred.
1571 of 24.
was preferred by the Union of India. Full stop. Another appeal being MAT number
1571 of 2024.
was filed by the private respondents in the writ petition. Full stop. The aforesaid appeals stood dismissed by a judgment and order dated August 19, 2024. Ms. Alam Learned Advocate submits that the alleged contemners have instructed her that steps are being taken for preferring a special leave petition before the Honorable Supreme Court challenging the judgment and order dated August 19, 2024. Yes, how much time you want? Acha, since the Union of India is contemplating to file an appeal, let this matter go out of the list for the present with liberty to the petitioner to pray for its inclusion.
Milord, one more thing, Milord.
Upon notice to the learned advocate for the alleged contemner.
Milord, one more thing, Milord. The post of DIG, DG,
Has
Milord,
changed.
no, incumbent has changed. So we have given him notice also stating that we'll pray for incorporating his name in the array of respondents.
Can do
Milord,
that
let
because
liberty- Milord, we
that
can
is-
change the cost title.
in the meantime, if further change happens,
If further
if
change-
in the meantime further change happens, again it has to
Yeah.
be, let it remain as it is.
Then it can be changed.
But Milord, my duty to bring it, Milord, I have already served notice upon the new incumbent also regarding the violation.
Then leave is granted to.
Milord, since I have served notice
As
upon
prayed
him,
for
Milord,
by Mr. Shaw, এটা করে দিন। As prayed for by Mr. Shaw, the learned advocate on record of the petitioner is given leave to amend the cost title of the contempt application by adding the name of the new
Present in-
incumbent to the post of
DG,
DG, Director General,
BSF.
BSF. Let such amendment be carried out
Here and now, Milord.
here and now.
What is it, huh? Hey, Ranjit.
Yes.
Fixed matter.
Lordship, I will appearing for petitioner.
My lord, I am for the respondent number 7 and applicant, but
Yes.
affidavit to it. Yes, my lord, on the previous occasion, your lordship was pleased.
But directed to file an affidavit.
My lord, this is the affidavit, my lord, in the writ petition, and my lord, for the recalling also, I have filed one supplementary.
Recalling supplementary is with regard to that statement only.
Yes, one mistake.
Where is that?
My lord, statement, that is, my lord, in the recalling or my lord, the writ petition?
No, where have you stated this? That
Both I am
in
stated.
both.
My lord, let it be taken up, because if the writ petition is hard, my lord, then recalling will be redundant.
All right.
Yes.
In the affidavit, supplementary affidavit, you have stated that. Where is that?
My lord, the first,
Which paragraph you have stated that?
my lord, 4.
Paragraph.
And my lord, before my lord opening, I humbly submit, my lord, that before all.
Paragraph 4, which subparagraph? Paragraph 4 contains many.
4 is, my lord, it is humbly stated and submitted that I am not willing to pay any additional amount for the period starting from 1st December 2024 to 29 July 2025 in connection with the lease for.
All right, all right.
Wait,
Before starting of the sub-paragraphs, all right.
total
yes.
For the following reasons that I have stated.
All right.
My lord,
So let the writ petition be heard out.
as
yes.
Lordship would be pleased.
Yes.
Lordship, in this particular issue, I have objection,
All right.
and this is
The
not very
petition.
important, my lord.
Move the writ petition.
On their affidavit, my lord, I have some exception.
Move the writ petition.
Yes, my lord, I am moving. Lordship, at the very first, I beg Lordship's attention to the first order that was passed by the then Lordship was Sampa Sarkar, and it was on 27th September 2022.
27th?
September 2022, my lord.
Yes.
I came before Lordship on August because tender was closed in July end, and by that time there was no steps, and I had made several petitions before the authorities that they go for fresh tender, and without any further steps, we came to this petition, my lord. And Lordship, after hearing, Lordship was pleased to determine the issues on certain aspects. Our statement is on record, their statement is also record, and determination is also there, my lord. That is the thing I am.
Yes. What are you challenging?
My submission on that point, determination on the part, issue was framed by our ladyship, Sampa Sarkar, Honorable Justice, my lord. The additional district magistrate, AEO Jela Porishad, was asked to clarify her stand. The previous value must be assessed, adjudicated upon the granting opportunity to the said authority to file affidavit explaining the reasons behind such decision. The reasonableness of the decision and correctness of the have to be decided thereafter. And unfortunately, and it was fixed for January 23, my lord. And unfortunately, by this time, 2 years have almost lapsed. And Lordship, in your Lordship's order, there is also the determination that
What is the basis of
my
allowing extension?
my submission in this contest, my lord? Their claim is, at least what they have claim is, they have got.
Where is the decision to grant extension? Where is that?
Page 28, my lord of the writ
Page
28.
88.
28.
28. No, 28 is the money receipt. Oh, sorry. I'm looking at the recalling application. '28, yes. Yes.
My lord, their term to expire on 29th July of that year, 22. And very interestingly, in more than 3 months back, the order was passed and extension was made. And in this situation, AEO Jela Porishad, what clarification he raises? Lordship, I raised in my petition with certain legal questions. Unfortunately, he has replied the page. In this situation, my lord, my question was,
have they explained this fact in the affidavit?
Yes, my lord.
That?
They have not explained anything. The only explanation is that,
Where
my
is
lord.
the affidavit of the state?
This is the affidavit, my lord.
R5, respondent number 5.
Respondent number 5.
He extended the order.
Yes, respondent number 5.
Yes, my lord. My query to the law points was whether the awarding of
Give me a
the,
minute, give me a minute.
yes.
Yes,
Yes, my lord. My points was whether the awarding any contract or lease or state authority is adopt to any transparent or fair method or harnessing the best available price. Their reply was yes. This means they are committed to following transparent method. Then comes to my question second, whether the public auction is to be compulsorily adopted by the public authorities in awarding lease, license, public property or existing service to the public generally. There again, stand is yes. Then I am coming to the third question, my lord. Whether the public authorities are duty bound to ensure that no nepotism, favoritism, and impairs awarding of any contract or public authorities. They are also stand is yes. Whether public contract can be surreptitiously awarded at the cost of the public exchequer. Their stand is no. Whether public authorities at Malda Jela Parishad can extend the lease period of ferryguard at the cost of public exchequer and without resorting to any public auction. No. Last question, my lord. Whether the public authority is under solemn duty to respond to the repeated representation made for it. Yes. My submission in this point was I made 3-4 petitions and those are in the annexure.
yes.
I have been replied with not a single one. But my lord, in the previous day, state's submission was, and lordship was pleased to take it on record, that on the recommendation, it is on the report para 8, my lord, affidavit.
Yes.
As per recommendation, the Kormataka Puribohan Sthayi Samiti and Savadipati of Jela Parishad of Omuk at the rate of 15% enhanced rate per year, previous lease, valued certain year. My submission in this point, if it is the question of open tender, can anyone recommend someone's name and that can be extended? If the reasonableness is the issue,
Where is the question of recommendation of a particular person's name?
yes, my lord. In the same affidavit in opposition in the para 8, my lord.
Yes.
These two functionaries, my lord, they recommend
No,
someone's name.
this recommendation was at annexure 8. Recommendation is at annexure 8.
And it says,
Page 80.
coming to the point, my lord.
There is no name of any particular person.
If extension is to be made, if it is the same very, naturally his name comes, my lord.
All right.
Naturally,
That is
the single issue, my lord.
yes.
To my submission in this point, if reasonableness is in question, if fairness is question, if transparency is question, and if it is question that admitted position is that free and fair auction process should be there. This is the admitted position. Yes, is their reply. So can they go for recommendation and someone's, and they go to the extension for 3 years. It is astonishing. If recommendation matters, then they could have extended to 30 years, 300 years. If it is 15%, they could have been minus 15% also. That could have been 150%. All these are illogical, whimsical, total arbitrariness.
Anything more?
My submission in this point, my lord, they have relied on one resolution, my lord, that this has been adopted in a subsequent resolution. I am just coming to that point, my lord, the contents of the resolution.
Page 20 of the affidavit.
20, my lord.
Yes.
There are so many agenda, and agenda 5 was concerned with this issue, my lord.
Agenda 5, yes.
আলোচ্য সূচি অনুসারে ফেরিঘাট সংক্রান্ত আলোচনায় মাননীয় অতিরিক্ত জেলা শাসক তথা অতিরিক্ত জেলা নির্বাহী আধিকারিক জেলা পরিষদ থাকাকালীন ফেরিঘাট থেকে আয় সংক্রান্ত বিষয়ে নিয়মিত পরামর্শ প্রদান করেন। হি ইজ অ্যাডভাইসেস সামথিং দেখা জাস্ট আই এম রেজিং দ্য পয়েন্ট মাই লর্ড। হিজ প্রপোজাল ইজ সার্টেন ফেরিঘাট বন্দোবস্ত করা যেতে পারে। যে সকল ফেরিঘাট বন্দোবস্ত দীর্ঘদিন যাবত জেলা পরিষদ অর্থ প্রদান করছে না, সেই সমস্ত ফেরিঘাটের বন্দোবস্ত গ্রহণকারীদের
Interested in the third bullet point.
Yes, my lord, third point. অতিরিক্ত জেলা শাসক নির্বাহী পরামর্শ অনুযায়ী ফেরিঘাটের নিম্নলিখিত সিদ্ধান্ত গ্রহণ করা। What is the decision? Decision is মালদা জেলা পরিষদের যাত্রী সাধারণের ভাড়া গ্রহণ করা হবে এই শর্তে they have prescribed rate. বন্দোবস্ত মেয়াদ উত্তীর্ণ ফেরিঘাটগুলিকে উত্তীর্ণ ফেরিঘাট পুনরায় বন্দোবস্তকারী পুরনো বন্দোবস্ত অনুসারে 15% বর্ধিত হারে মূল্য প্রদান করা হলো। Those ferryguards, this is also challengeable, but this is not my concern. Of those who has term has expired, but in this case, my lord, term has not expired. Term is to expire after 29th July. That is the date up to which it is effective. Naturally, my lord, they extension is made in April itself. Decision is taken, and this decision has no relevance with regards to that very regard upon which some extension has been made, because it is not their subject matter of discussion. If they rely on this document, this does not favor this case anyway, my lord.
Legal provision.
Yes.
And then I am coming to that point, my lord, in the legal provisions. Firstly, my lord, tender was of 30 lakh. Whimsically, they, in a local amendment, they came down to 10 lakh. This means 66.66%, 67% are gone at the very beginning. Then, my lord, after 10 lakh, it is 15, 15, 15, 15 in it. My submission to that point, my lord, if any tender and huge public money is involved, and as per their statement, they had made certain applications. In their findings, in their determination, there is no reference that whether they had multiple and it has been considered or rejected. And in the order of the AO Jela Porishad, there is no such reflection. There is no reflections in the resolution itself. Resolution says, my lord,
পরিকল্পনা উপসমিতি is the competent authority, not the কর্মদক্ষ of the পূর্ত। পূর্ত is not the competent authority. ওই provisionটা
বলছি কত জানো 29/10, তাই তো? My lord, if a leaseholder makes, my lord, I am submitting the West Bengal Jela Porishad Panchayat Accounts and Financial Rule 2003.
Yes.
দিদিন আমার থেকে পড়ুন।
For what proposition?
If in case of any compromise in the rate or anything is done, how it to be looked into?
Compromise of what?
If they make the suggestion, it is a great loss on the part of the panchayat.
Yes.
If it is not done, if they make any sorts of accommodation, how these things should be looked into?
Right.
That is the thing is dealt with under section 29 rule, my lord.
Yes, give me the book.
10. 29, 10, my lord.
Rule 2910.
Yes, my lord.
From remission of revenue.
No, this is with regard to remission. It's not a case of remission. Remission will take place. Let us assume tender was accepted for price X. Now someone comes and says, no, kindly, I want remission for A, B, C, D grounds. I want to pay X minus Y amount.
Yes, my lord.
For that, this is not a case of remission.
This is the analogy in that sense, my lord. If their claim is that I have made huge loss during the COVID period and everything,
They could have claimed for remission.
they could have claimed. They have not.
All right. So according to
Subsequently,
you, if during the COVID period they have made a loss, they could have paid for remission.
Remission,
that?
they have not paid. And they have, on agreed point, they have accepted 15% enhancement each year.
This, according to you, could not have been done.
Not only this is, I had in my presence, I'm not insisting on that point, my lord, basically at this moment, but my submission is, lord, this is a pure internal deal, my lord. Otherwise, without any source of background, how this issue 15% can be raised? When there is the provision 30 lakhs.
I followed your submission.
But
Yes,
my-
state.
Then I am coming to the case laws, my lord.
What case laws you will submit?
Case laws, in that
point.
In that point, my lord, there is government policy that 15% will be enhanced. This is the policy that extension can be made. All these issues has been determined in Kausalali versus State of West Bengal, and that issue very elaborately dealt with.
Give me a copy of the judgment.
Yes, my lord.
Is an unreported judgment?
No, my lord.
Reported. Give the citation so that
This is this
court.
court.
You have an extra copy.
From India.
India Kanun.
This is this court
You have
order.
an extra copy. Give a copy to them also.
Honorable Justice Sampa Sarkar's order is also, my lord.
Yes.
Which? Observation of the Lordship's order was that the court does not find any rules with regard to settlement of ferryguard and circulars issued on the behalf permit continuation of the operation after expiry of the lease.
Which
Paragraph? Page 3, my lord. Last paragraph, my lord.
Page 3. Yes.
This is the observation. However, the court sitting in the judicial review under 226 cannot direct the authorities to allow the petitioner to operate the indefinitely without legal basis backing. This is a policy matter entirely within the domain of the executive. Then, Lordship, third line, transparency and maximization of the revenue by allowing all eligible persons to participate in such instance is the correct method. And Lordship's in last day's orders, Lordship's observation was that extension should not have been there. Lordship has.
Don't rely upon the observations of the court on the earlier day.
Okay, my lord. In the paragraph 5,
earlier new day.
Paragraph 5, my lord. The government must have freedom to contact. In other words, a fair play in the joints is a necessary concomitant to the administrative body function in an administrative sphere or quasi-administrative sphere. However, the decision must not only be tested by the application of the witness's principal reasonableness, but must be free from arbitrariness and not affected by bias and actuated by malefites. And this malafiteness was the question of the Lordship's order in the previous occasion in 2022. Lordship was pleased to depend on very important two judgments, my lord. One is, we are very aware of the two spectrum judgment that was ultimately quashed, and it was a very serious political repercussion in this issue, my lord. 2G spectrum case, and it is in the paragraph 5, last case, my lord. In the matter of Central Public Interest Litigation versus Union of India, that is a reported judgment in SCC, my lord. And ratio is fixed there. And this case relates to the 2G spectrum scam case, my lord, wherein the 2G spectrum entire policy was scrapped and fresh tender were invited. In this situation, my relevant portion, to put it differently, the state and its agencies, instrumentalists must always adopt a rational method for disposal of public property, and no attempt should be made to scuttle the claim of the applicants. When it comes to the alienation of scarce natural resources like spectrum, it is the burden of the state to ensure that non-discriminatory method is adopted for distribution and alienation, which would necessarily result in the protection of national and public interest. This was the observation. Then another observation, my lord. Paragraph 26. In our view, the duly publicized auction conducted fairly and impartially is perhaps
Paragraph
the best
26,
method.
where do we find the paragraph number?
Next page, my lord. Just next page,
Page,
my lord.
yes,
Yes. Top portion, my lord.
yes, 96, yes.
Nice, my lord. In our view, duly publicized auction conducted fairly and impartially is perhaps the best method for discharging this burden, and the method, the first come first basis, when this alienation of the natural resources, public property, etc., likely to be misused by unscrupulous people who are only interested in and the last line, while the transferring the natural resources, the state is duty bound to adopt the method of auction
Yes.
by giving the wide publicity so that eligible
I've seen
persons
that.
can.
Anything more?
Now, last, just this court's order, my lord, and this is the last year in Conjugal Group Samiti case, and it was the reference of the WP number 2851 of 2005's order, my lord.
Yes.
His lordship has categorically held that prayer for renewal of lease and extension period of the lease could not be granted, as it was opposed to public policy, and the selection should be made either by auction or by tender. My submission is this.
Have you brought this decision 2851 W of 2005?
No, my decision was that when I made the question.
আছে কম্পিউটার এই জাজমেন্টটা বার করা যাবে কিনা দেখতে বলুন তো একটু সাইড থেকে WPA 2 এটা
What the questions I made out in my petition, my lord, these are the extract from the case laws, what the things I should ask from the authorities. And in all these points, they accepted my position that auction should be there, transparency method should be there. And very unfortunately, even prior to 3-4 months, prior to the expiry of the tender, they, in a stroke of pen, extended the wide without any consideration. And this is the glaring example of arbitrariness. This is the public policy, huge involvement, and this is his client has withdrawn his commitment, but my client, I am unfortunate, my client has kept full reliance upon me. My commitment on that previous day was that I am ready to pay 100% extra. This means the double amount. I am sticking to that point also, my lord. If I am allowed to participate in the lease process or it is cancelled, my demand is it should be cancelled from immediate effect, because they are gaining almost 100% of their investment. This cannot be. And for the sake of public interest, for the sake of government fund, public parts, we are ready to pay the double amount from today, my lord.
all right. Yes, madam, come this side. Yes.
Well, I can't improve
Madam, kindly use the microphone.
can't improve my affidavit in opposition. my lord. What is there in the affidavit in opposition. This has been filed by the state.
What is your submission?
My submission is, my lord, that
You want to make any oral submission or you want to rely only upon the affidavit?
I can't go beyond my affidavit.
All right. Yes. What do you- Thank you. Yes.
And I'm relying on the last annexure, my lord, page 20.
Page 20.
Yes.
Yes.
The resolution was made, and
So according to you, as per this
resolution, yes.
recommendation,
the-
the extension was granted. Anything more? Yes.
Yes. My lord, in my supplementary affidavit, I have stated categorically that what was the scenario. Only one page of the resolution has been given in the affidavit of state. And my lord, from the state's affidavit, I will show before your lordship, this kind of affidavit I have never seen, that one state authority has taken the decision, same post, same authority is disowning his decision. That I will show.
Where the state has
My lord,
dissolved.
yes. My lord, that is state affidavit.
Yes.
My lord. That is, my lord, one he has not, my lord, whether public auction, the first, number 2.
Ms.
at page-
Bhattacharya, give me a minute.
Okay.
Yes, page.
My lord, page 4, point number 5 of the table, which has given by the state.
Page 4, point number 5. Yes.
5. My lord, whether public authorities at Malda Jila Parishad can extend the lease period of ferryguard at the cost of the public exchequer and without resorting to any public auction. Answer is no. My lord, if no is there, my lord, who is, my lord, giving this affidavit? My lord, that is additional district magistrate, Malda, and additional executive officer, Malda Jila Parishad. Same officer has extended. My lord, he cannot, my lord, disown his own action by affidavit. This is, my lord, cannot be done. And my lord, another point is that,
Then Ms. Bhattacharya, what should be done?
my lord, that is,
I'm asking you. This,
my lord,
he is now saying no. What is the effect of if these two decisions, extension and this, are read?
my lord, the state has to take the action with the affirming officer. Or, my lord,
That the state will do.
yes, and my lord,
State will be free to do that. So
No,
what the court will do now?
yes, what the court will do now, my lord, first of all, my lord, I do not want to say anything because whether,
All right, you can make your submissions. You don't need to say anything. Yes.
my lord, whether there is any, my lord, connection or nexus between the petitioner and, my lord, the affirming officer, I do not know. Without knowing that, my lord, I cannot say. Because by way of affidavit, no one can disown his own action or anything. It is, my lord, one kind of, my lord, service, my lord, it will come under the service jurisdiction. Because he is not, my lord, doing as per the government official can do any conduct. It cannot. And punishment, my lord, that is, your lordship is also, my lord, can, his lordship is, if lordship may be pleased.
Employer is the best person to take
Yes,
disciplinary
yes,
action.
yes. And my lord, how it can be, that I do not know. And my lord, now I am coming, my lord, from the supplementary affidavit, I am,
Your supplementary affidavit.
Yes.
Yes.
yes, my lord. And his, my lord, prayer is only for fresh auction. Now, my lord, no, there is no scope to give extra amount or anything, any like.
All right. That chapter is closed now.
Yes. And my lord,
That chapter is closed now.
yes. And now, my lord, my specific case is that what he is trying to establish that Jila Parishad has some malafide or I have some malafide in such kind of extension. My specific case is that there is no undue favor has been bestowed upon me and no malafide was there. It was the policy decision to extend and I have annexed all the lease. It is not the unholy nexus between me and the Jila Parishad. There are several throughout the district. It was extended by way of decision of the Ortho and Sai Shomiti. And my lord, not only this district, I will, my lord, place the judgment passed by your lordship and also the Honorable Justice Champa Sarkar in respect of the district of Murshidabad. My lord, the situation time is, my lord, the crucial because 20 and 21, all of us were suffering from pandemic situation. And for that, my lord, considering the situation that, my lord, several businessmen has lost their and some subsidy, something in different way, in different trade, in the government has given that benefits to the business persons or in different strata of the society. And my lord, therefore, that I will show the.
So is it your case that this extension
Yes.
was given
Yes.
to compensate the loss
Not only
which the
compensate.
parties suffered
No, not,
during the COVID period.
my lord, not only compensation to the business person. It was, my lord, the economic consideration, because of, my lord, at that point of time, every sphere of the business world was suffering from financial crunch.
If that is accepted, the
Yes.
petitioner also suffered from financial crunch.
Yes, that I have
So
stated.
petitioner could have earned this. One thing is to say
Yes.
that to compensate the loss for the COVID period.
Yes.
And if another thing you want to say, the businessmen are to be given the job, then the petitioner also are to be entitled to that.
No, businessmen not have to be provided.
Everybody suffered loss during
Yes.
that period.
And
One thing is it your submission that to compensate the loss?
that was my application, that we have already suffered during the COVID period because jetty was
Have you
closed.
quantified your loss?
Well, at that point of time, there was no quantification of loss.
So how could you say that you have suffered loss?
No,
Without quantification,
my lord, because, well,
you have said you have suffered a loss. You have to quantify that this thing in the normal period, I could have earned this, I've earned such and such, because subject to say you are claiming a benefit on the ground that you have suffered loss. Without quantification, without any materials,
my lord, I only prayed for.
you say that you have prayed for,
Yes.
in consideration of that, it was allowed. That is one
Yes,
thing.
that is.
Show me
is
that in
okay.
consideration of that, it was allowed as a single case of yours.
No, my lord, not a single case. My lord, I am
You said,
saying-
Ms. Bhattacharya, you said you have made a prayer
yes, my lord, that
and
is
it was
done
allowed.
on that
Then it
document.
has to be considering your prayer, not everybody's prayer.
My lord,
Show me that your prayer was considered and a decision was
it was
taken.
considered a such kind of application made by all the, my lord, Fedigat, other Fedigat.
Show me from the decision, it
Yes.
states so.
Yes, my lord, kindly have a look. It is, my lord, my application, my lord, it will be,
No, page 20 states affidavit, that is the decision.
no, my lord, state's affidavit, it is not my. No,
How could you annex the decision of the authority which the authorities have not annexed?
no, it was my.
You are
lord,
saying that on your petition, decision was taken to extend.
No. my lord,
Grateful to
my-
lordship.
My affidavit in
Take your seat. You
I
take your
have
seat.
annexed, my lord, the supplementary.
Yes. Which document you want to show from your
No, my
supplement?
lord, my application was, my lord, here. That
Yes,
is, my lord, my opposition at page 13.
your opposition.
Yes. Supplementary to দিয়েছিস দিসনি তো তো অ্যাপ্লিকেশনটা যেটা
You are 7, respondent number 7,
yes
page,
হ্যাঁ মানে অ্যাপ্লিকেশন ফর এক্সটেনশন অফ লিজ
page 13.
পেজ 30
Yes.
এই মর্মে আপনার দৃষ্টি আকর্ষণ করিতেছি যে আমরা বেকার শিক্ষিত যুবক গত 7/8/2020 আপনার করণ হইতে বলরামপুর ফেরিঘাট লিজে নিয়েছি যাহার মেমো নাম্বার সাচানসা কিন্তু সারা বিশ্বে যে অতিমারি প্রকোপ এর ফলে বেশি সময় ধরে ফেরি চলাচল বন্ধ থাকে ফলস্বরূপ আমাদের অর্থনৈতিক দিক থেকে একদম ভেঙে পড়েছে আমরা প্রাইভেট লোন পাবলিক লোনে জর্জরিত হয়ে পড়েছি বর্তমানে আমরা ফেরি পারাপারের সরঞ্জাম থেকে শুরু করে সমস্ত আসবাবপত্র ক্রয় করিয়া ফেরি পারাপারের সুন্দর ব্যবস্থা করিয়াছি এবং যাত্রীদের সঠিক পরিষেবা দান করিতেছি মহাশয় আগামী ইংরেজি 29/7/2022 পর্যন্ত আমাদের লিজের সমস্ত টাকা আগাম পরিশোধ করিয়া দিয়াছি বর্তমানে আমরা ঋণগ্রস্ত এমত অবস্থায় আগামী 3 বছরের জন্য ফেরিঘাটের সময়সীমা বর্ধিত করার অনুরোধ করিতেছি অন্যথায় আমরা সপরিবার দেনার দায়ে ভেঙে পড়ব অতএব মহাশয়ের নিকট আবেদন আগামী 3 বছর পুনরায় ফেরিঘাট এক্সটেনশন করে আমাদের সকলের পরিবারের পাশে থেকে সুস্থভাবে থাকার জন্য বাধিত করিবেন
Yes.
This is my lord one. Now, my lord, I am coming that it was extended, my lord. My lord, the Jila Parishad is not appearing before your lordship. The reason is best known to that authority. My lord, the next page, my lord, 40.
Yes.
They have extension order to the lease period of Balaram Ghat, erstwhile Pirganj Ghat, with yes, with effect from 30th July 2022, 29th July 2025. Now, my lord, I am coming from the, my lord, supplementary affidavit, my lord, the resolution. Why, my lord, this kind of post facto has done? My lord, kindly have a look at my supplementary affidavit to the writ petition. Because it is the public service, it cannot be stopped in that way. For that reason, my lord, the page 9.
Supplementary affidavit.
Supplementary affidavit.
Yes.
Alosho Chuch, my lord, can be. Supplementary affidavit of to the writ petition. No, to the writ petition. Supplementary affidavit to the writ petition. I writ petition or to opposition. Yes, sir. না না মানে to the writ petition supplementary. জজ সাহেবের অর্ডার অনুযায়ী affidavit upon my lord on second December. Have you looked at?
Yes.
Got. My lord, page 9 of the supplementary affidavit. Filed by me.
Page 9.
আলোচ্য সূচি অনুসারে মাননীয় অতিরিক্ত জেলা শাসক তথা অতিরিক্ত নির্বাহী আধিকারিক মহাশয় সভাকে জানান গত 23/11/2022 তারিখের পর বিভিন্ন কারণে জেলা পরিষদের অর্থ স্থায়ী সমিতির সভা করা সম্ভব হয়নি, কিন্তু ওই সময় স্থানীয় জনসাধারণের সুবিধার্থে বিভিন্ন সময় পাড়ায় সমাধান সহ অন্যান্য উন্নয়নমূলক
So which agenda you are placing?
মানে that is
Which agenda number?
আলোচ্য সূচি 3.
3 is not with regard to this extension.
No,
5 is with regard to extension.
So why, my lord, this kind of that extension was given me in April,
Yes.
and my lord, that was post facto approval came, my lord, later. For that reason, I am placing this that this meeting could not be held by the Jila Parishad for various reasons, for various occasions, various programs. For that reason, then, my lord, the next decision came that Manoniyo, that is at page 10. Which
Yes.
also relied by my friend also.
Yes.
Yes, my lord. Because of it is the public, my lord, service. So it cannot be stopped in any way. And for that reason, my lord, as the meetings could not be held, then, my lord, they have come to this decision that মালদা জেলা পরিষদ নির্ধারিত যাত্রী সাধারণের নিকট ভাড়া গ্রহণ করা হবে এই শর্তে বন্দোবস্তের মেয়াদ উত্তীর্ণ ফেরিঘাটগুলোকে পুনরায় বন্দোবস্তকারীদের পুরনো বন্দোবস্ত মূল্যে 15% বর্ধিত করে পুনরায় বন্দোবস্ত প্রদান করা হলো। And now, my lord, from my supplementary affidavit, my lord, let it be, my lord, the all others, because of this, thereafter one by one it was extended. My lord, kindly have a look from page, my lord, 24
Of the supplementary.
of the supplementary.
Yes.
Connect all
No, all means.
all others throughout the district.
Yes, yes, yes.
Well,
Yes.
my lord, that is, my lord, start from page 25. Extension, it is not mine, my lord, Borkole Ghat. My lord,
Yes.
kindly-
Because within entire Malda Jila Parishad.
Malda.
Yes.
Entire Malda, my lord, it was done. So it was the policy decision of the Jila Parishad. What were the factor they were considered? That is the economic factor, public factor, demographical factor. That is up to the authority. That is not with me. But my lord, it is not any malafide or any undue advantage was provided to me. That is my case. So it is not that any malafide intention, Jila Parishad has done so, and he has not challenged that. He has challenged on.
So why no auction could not be held in 2022?
No, my lord.
Why?
And entire
Why?
Bengal, my lord, it was
Why?
done.
Why? I am asking
That
why.
Government authority can.
And when initially the lease was granted in your favor,
That was auction.
what was the date?
That is for 2020. It was
But
given.
I want to know the month. That will
No,
be very
my lord,
relevant.
auction has to be called earlier.
Yes,
and
yes,
it
I
was
want to
processed.
know. I want to know the month, date, and year of the earlier auction.
ওই যে writ petition এ দেখো,
July
2020.
July 2020.
No, it was extended, but auction কবে রেখেছিল?
order date was of July.
হ্যাঁ, order
24 July to
When
21.
the earlier auction was held?
auctionটা কবে? নোটিশ ইস্যুটা
24 July, my lord.
হ্যাঁ।
20.
কত নম্বর page?
You have not stated in your supplementary affidavit when the earlier auction was held?
And it is not in dispute.
No, 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 no. That will be relevant.
Yes.
It's not a question of dispute.
Exactly.
That is very much relevant.
It is in the annexure of the AEO Jila Porishad, my
হ্যাঁ,
lord. It is in the annexure of the Jila Porishad, my lord, in annexure E, my lord.
my lord, and read petition 15, page 15.
Annexure of the Jila Porishad.
Yeah, Jila Porishad, annexure E, my
Yes.
lord.
জেলা পরিষদ কোথায়? জেলা পরিষদ
AEO Jila Porishad.
মানে জেলা পরিষদ had not submitted any affidavit.
এইও জেলা পরিষদ এইও জেলা এডিএম জেলা পরিষদ তো
ADN, my lord, Jela Parishad and state is not the same body. The state advocate cannot appear on behalf of the Jela Parishad. Jela Parishad has to, my lord, without any.
Yes, affidavit of the respondent number 5.
Yes, my lord.
Which page was the earlier auction?
Earlier auction, annexure E, my lord. Pa-
ওটা তো 13 July 2020.
Yes. So
24th July.
place of auction was July 2020.
Peak,
So July 2020 auction could be held.
peak of it.
Could be held.
Yes.
But in 2022 it could not be held.
No, my lord, 2020 it could be
Could
held.
not be held.
No, thereafter, my lord, they all the
So what
throughout,
was the reason for extension?
my lord, extension is the, my lord, lot suffered by the
Only
entire
to-
community.
Oh, yes, only to compensate for some parts.
Not some persons, my lord. If it is some, if I was.
No, 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 I'm not an individual. The existing one. who are offered.
Existing all, my lord, throughout.
Yes,
the
yes, all.
Was.
All within Malda.
Not Malda.
But,
all district also.
and who was the existing one in July 2020?
My lord,
He should have been extended during that period. Peak COVID.
my lord, he did not apply. He was the.
No, 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 who
existing.
was
He was the existing.
So the extension could have been granted. That decision was not taken.
My lord,
At that point of time, public auction.
My lord,
But in 2022, when everything became normal, auction could not be held.
my lord, there, the reason, my lord, here that 2020 auction claim, auction, my lord, floated. But, my lord, they did not object that. They did not pray for that. They have not come to the court.
Now, that is my accepted, I participated. There is other anomalies.
He could
So where
not
is-
be the best bid, highest
Yes,
bidder.
yes, you got in the auction.
Yes.
There is no difficulty on that.
But,
There is no difficulty, but
when
at
we-
that point of time, auction, he was defeated, he was the existing one. At that point of time, auction.
Yes.
But now the existing has to be
No,
extended.
my lord, throughout this year, because of different, my lord, of.
And for that, for 3 years, without any quantification of damage. What was the earlier
Madam,
period for auction? What was the earlier period of the lease?
2 years.
2 years.
2 years.
Extension for 3 years.
My lord, that is, my lord, in different matters. my lord,
Extension for 3 years.
3 years.
Initial for 2 years.
Initial for 2 years. That I cannot, my lord.
Thank you, Ms. Bhattacharjee.
No, my
Do you
lord.
want to rely upon any
No,
decision?
my lord, here, my lord, another is also there, my lord. Kindly have a look, my lord. And, my lord, there is no, my lord, legal, when I have paid, my lord, the money.
Yes, yes.
Entire money for this period. And for that reason, my lord, I have accrued some right.
You will again pay for money from in July 2025. In April, you will continue.
No, no, that will not be. They will call the fresh auction. I am not praying for the extension. At this time, my lord, I have paid the entire money, 41 lakhs, and not at the cost of the public exchequer. At the enhanced rate, it was the decision. It is the.
If a further, that is why I asked you,
Huh.
if the rate could be further enhanced, you had a problem in that.
No, then my.
You have said 15%.
Yes.
If it could have been enhanced to 75%,
If it
you had
is-
a problem in that.
No, if it is open auction,
State exchequer will,
my lord,
Bro,
state
Ms.
exchequer.
Bhattacharjee, instead of 15%, if it is 75%, state exchequer will grow.
But
You will also be happy
No.
for that. You must be happy for that.
Obviously, my lord.
But you are not agreeable for that.
No. My lord, the problem here is it is the executive decision, my lord.
Yes, yes.
What would be the best? My lord, I am putting question to myself. Can it be, my lord, the subject of the judicial authority? I am, my lord, showing the Supreme Court judgment on
That I will
everything.
decide in
And,
this.
my lord, only pandemic situation.
That will be the decision.
Yes. My lord, if, my lord, it is the executive decision they had taken and not any, I am not singled out to give any malafide benefit or any undue advantage. It was the decision taken throughout the state, not only throughout the district. All in the all Jela Parishad, it was extended like that because all of us had suffered a huge loss during this period. 20 and 21. Auction, my lord, everything was skeleton work was done. Because of this, my lord, it could not be held. It is related with the public service. And my lord, what were the consideration that the Shomiti Ortho and Sai Shomiti had taken the decision, that only, my lord, the factors can be explained from the Jela Parishad.
They have disclosed the documents.
They have not. State is not the Jela Parishad. I am, my lord, kindly record it.
All right.
Because without any
Any
Mukaddam Nama-
decision you want to cite? Yes.
I am coming. And now, my lord, I am distinguishing his decision. That I am coming. What decision?
You can rely first upon the decision you want to cite, then distinguish.
Yes. As your lordship will, please. যে ওরা দুটো দেয়া যায় আমাদের কোর্টের দুটোতে তারপরে যেটা মুর্শিদাবাদ ডিস্ট্রিক্টে জলসাহেবের আগে যে দুটো মানে this is your lordship's judgment. এটা হচ্ছে গিয়ে মুর সালিম শেখ বাস in respect of Murshidabad district, your lordship has placed this allowed this extension, such kind of extension, and my lord, relying upon the another judgment, my lord, it is the Honorable Justice Shampa Sarkar, my lord, Ustad Ali Sheikh Enterprise. Na দিয়ে দিলাম তো জজ সাহেব। My lord, may I permitted to read, or your lordship is reading through? Five. In this process, my lord, your lordship. Similar, my lord. প্যারাগ্রাফ গুলো আমার ইয়েটা কোথায় গেল এটা আপনারা কি ready? আপনার তো ওনার সঙ্গে তো লড়াই না, আপনার সঙ্গে তো লড়াই না দিচ্ছি ওনাকে দিচ্ছি তো
একটা তো
হ্যাঁ ওইটা দুটো দিয়েছি, দুটো দেখাবো,
আরেকটা দেন
একটা উস্তাদ, একটা মুরাস হ্যাঁ মুরসালিম স্যার, আর একটা হচ্ছে উস্তাদ আলী শেখ এন্টারপ্রাইজ।
Yes, do you want to rely upon any specific portion of this order?
My lord, here, my lord, after discussing everything, your lordship has taken a decision since the coordinate bench of this court, after setting aside the e-auction notice, dated gave the liberty to the Murshidabad Jela Parishad to act and proceed in accordance with law and take an informed decision, taking note of the right it had vested upon seventh respondent herein up to October 31st, 2023. This court is of the considered view that no relief can be granted to the petitioner. Here, my lord, what was that? Here also challenge was.
It was a case wherein after extension, e-auction notice was published.
Yes.
This was that case.
Yes. But that, my lord, here also challenge made in the writ petition was that the ferry guard was settled without.
Yes,
any
yes, yes.
process.
Ms. Bhattacharya, in this matter,
Yes.
initially an extension was granted
Yes,
for a period.
yes,
Then an e-auction notice was published
yes.
during that
Yes.
period for the same period.
Yes.
That was the challenge.
Yes.
That since you have extended, you could not have.
Yes.
That was the subject matter of challenge in this writ petition.
There was no other competitor basically. And here is the competitor.
No, not that.
Another,
Yes.
my lord, Ustar Ali Sheikh. Ustar Ali Sheikh, this has been relied, my lord.
Which he has relied upon.
No, I am relying.
Where is that?
I have given one.
Yes.
9512. My lord, I am reading. The petitioner is the existing operator. Initially, lease was granted up to September 1, 2020. 2020 for a period of 1 year, that is up to August 31, 2022. The lease in favor of the petitioner had been extended up to October 31, 2024. Here is my lord, initial was 1 year, then it was 2 years. By the Murshidabad Jila Parishad, this has been relied by your lordship. By the Jila Parishad upon enhancement of the lease rent by 10%. It has, my lord, the percentage also differ from Jila Parishad to Jila Parishad. Such decision was taken by the Jila Parishad, taking into account of the losses which the existing operator had suffered due to pandemic situation. My case is also that such extension was intimated by a letter dated, my lord, October 8, 2021, that is prior to. Challenging such extension, an interested party filed WP.
So this, I think there is a typographical mistake in the second paragraph. It should not be August 31, 2022. It should be 2021.
No, my lord, yes.
It has to be. Otherwise,
Yes,
the next sentence,
It
1 year has
Yes.
to be 2021.
It has to be, my lord. And then, my lord, it was extended, my lord, such extension intimated October 8, 2021. Challenging such extension, an interested party filed WPA 680 of 2022. The contention of the said operator was that the settlement ought to have been made by e-auction. The Jila Parishad could not have extended the lease. The Jila Parishad could not, the contention of the Jila Parishad was that the decision was arrived at in order to allow existing operators to make good the losses, as the ferry service was inoperative for a long time. Similar decisions were taken in with regard to many existing operators. This court did not pass any interim direction, as the court was of the opinion that the policy adopted by the Jila Parishad to protect the interest of the operators who had suffered huge loss could not be interfered with an interim stage without hearing matter on affidavits. Accordingly, by an order dated, such and such direction was passed. Then, my lord, Mr. Shen, an advocate representing the Jila Parishad, submits that in view of certain verbal observations made by the learned coordinate bench with regard to the extension of lease to the petitioner for a temporary period up to October 31, 2024, the e-auction notice was issued. Such observation was made in presence of the petitioner, who was the present respondent number 7 in the writ petition, and no submission had been made. That is, my lord, in view of some observation, they issued the e-auction.
Yes.
Although the Mr. Sen submits that the learned coordinate bench had made observations, but such observation had not been recorded in order. It appears that whereas, my lord, this code by an order dated such and such, upon taking note the policy adopted by the Jila Parishad to protect interest of the operators who had suffered huge loss when the pandemic had hit and the operation of the ferry ghats had shut down for a considerable period, did not intervene at the interim stage. Under Sadman, the next paragraph, under such circumstances, this court is of the view that in absence, my lord, I am relying on that, in absence of any particular direction upon the authorities to proceed with fresh e-auction by cancelling the extension given to the petitioner, the auction notice could not have been issued for a period which coincides with the period of extension already given to the petitioner. Here is also the same, my lord. I have accrued a right upon payment, and there is no legal provision, and without any legal provision, accrued right cannot be taken away. Then, my lord, coming, by a policy decision, the petitioner was allowed temporary extension of the lease up to such and such. The authority was within its right to either amend such policy or take a different view. after normalization of the situation. However, as a right had vested upon the petitioner on the basis of the letter dated October 8, 2021 to operate the ferryguard up to October 31, 2024 by the Murshidabad Jela Parishad itself, the Jela Parishad could not issue an e-auction notice behind the back of the petitioner and without withdrawing the settlement made in favor of the petitioner up to October 31, 2021 for cogent reasons. Moreover, the petitioner ought to have been heard. Once the authority had vested a right upon the petitioner, such right could not be taken away without any authority of law and for sufficient reasons, namely failure on the part of the petitioner to pay the lease rent or failure on the part of the petitioner to operate the ferryguard as per terms and conditions or a change in the policy and circumstances based on directions of a competent court on law. Under such circumstances, e-auction notice dated such and such is set aside and cancelled. For that reason, which e-auction your lordship was mentioning here, that is the reason. That e-auction, that is one of the judgment issued, passed by the your lordship. Your lordship was saying that e-auction was passed. For that reason, that e-auction.
Here also that.
Yes. Here also that, but cancellation, my right in favor of my right, it cannot be taken away without any legal provision. My lord, in the Panchayat Act, all.
Show me from this decision, this was the ground for extension, pandemic.
This was the ground for extension, my lord, that Jela Parishad can show.
That matter, it was there.
My lord, that Jela Parishad can show, my lord, I cannot show.
This is the decision. This is the recommendation on the basis of which extension was done.
I can file, that was the ground, my application
You
was.
may have, but that was not the ground for extension.
Yes, my lord, ground for extension, my lord, that was given that.
You have paid for an extension,
Yes.
but show me that ground was accepted and on that ground extension was granted.
My lord, that ground was accepted, my lord, one. But indirectly it was stated that the অর্থ এবং স্থায়ী সমিতি সভা করা সম্ভব হয় নাই.
That is a different thing. In June, that you are trying to show that it could not have been held prior to June 2022. Show me in the decision of 9th of June 2022, this was the reason for extension.
That, my lord, then I have to take that, my lord.
What instructions will take? You cannot improve upon this document.
No, my lord, here.
Because you are also not the authority, Ms. Bhattacharjee, now.
No, I have no authority for that reason.
No, you are not the. I'm not saying you do not have the authority. I'm saying you are not the authority.
That I am saying that it is with
So
the
since you are not the authority,
No.
you cannot improve upon this.
authority is maybe directed to appear. Well,
Bhattacharjee, if they choose not to appear, notices were served.
যে সকল my lord, here মাননীয় অতিরিক্ত অনুসারে ফেরিঘাটের বিষয়ে নিম্নলিখিত সিদ্ধান্ত নেওয়া হলো।
Yes.
আচ্ছা, বেঁধে থাকা সংক্রান্ত আলোচনায় মাননীয় অতিরিক্ত নির্বাহী সভাকে জানান এবার বিভিন্ন বকে যে দখল হয়েছে সেগুলো তো আলাদা ব্যাপার। Yes, my lord, here it has been stated that they have been allowed to be extended. It is stated in the ortho and sthai. And my lord, in my letter which was given.
And where is your extension letter?
Extension, that I am trying to find. Extension letter for.
It's page 19.
Yes.
13 of the of their opposition.
Yes, my page 13. My lord, it was 13 my application. I have stated that I have suffered a loss and for that reason let it be extended.
Show me that was allowed. That prayer, that ground, after taking into consideration that ground, extension was granted.
My lord, here it is to inform you that the lease period of Balarampur Ghat is hereby extended for period of such and such. But the reason.
Not as per the recommendation also.
Recommendation, my lord, which.
Affidavit says as per the recommendation of Sthai Samiti, it does not say so.
Well, that I cannot place that. That is, my lord,
So
unofficial.
that is their stand. That is their stand. But it does not appear from this.
Official record here from, my lord, the order which is to be issued. There, my lord, recommendation is may not be, my lord, mentioned. It is the, my lord, the file. In the file it may be. I cannot, my lord, have the access to the file. And one, that is,
Anything more?
yes, my lord, another is there. That- My lord, I have also stated in my supplementary affidavit that I have acted upon the letter of the Jila Parishad. On my own, I have not acted. And for that reason, the admitted amount which I have already spent,
Where is that?
my lord, that is here. That is, my lord, starting from page 4 from my supplementary affidavit.
Supplementary to the main writ petition or to
Yes.
the
And the writ petition.
page?
Page, my lord, 4. It starts from.
Yes.
Admitted all documents I also have annexed. Acting upon the government decision, the following expenses had been already incurred for the period July 2024 to July 2025, which are as follows. My lord, lease for 2 boats from one Dulal Ghosh through an agreement dated 25th July 2024. That is the amount, my lord, 6,48,000. And purchase of bamboos, 3,46,000. And hardware material, my lord, 50,000. And bricks from BFT Brickfield, my lord, 28,000. Sand from BFT Brickfield from 15,000. From the purpose of renovation of the ferry ghat, because my lord, the Jila Parishad is a custodian, either state or who are the operators.
What is the lease rent for this period?
My lord, that is 15 lakhs.
15 lakhs.
Yes.
And you have spent 25 lakhs.
No, my lord, 25 regarding taking consideration of the lease rent.
Oh, including that. So
Including
15 lakhs.
15 lakhs. Without, my lord, yes, 15 lakhs. And my lord, renovation I have to done because it is a public matter. And for the rainy season, 2 months before this, 2 months, ferrygut was closed. And for that reason, in the rainy season, my lord, that some storms has come, everything. So my lord, ferrygut was, my lord, destroyed. So I had to do this. Even I had to incur loss that I have to accept. Because when it has been destructed, I have to renovate it. If loss, that is the, my lord,
So
auction.
loss again, extension will be granted in your favor.
That is up to the authority. That is not with me. But in that case, all throughout the West Bengal in 2024 or 5, it will be extended. That may not be taken. That cannot be.
2022 it could be extended. 2020 it could not be extended.
No, my
Mr.
lord.
Bhattacharya, that is surprising.
No, my lord.
2020 it could not be extended.
Then was the.
But 2022 it could be extended.
My lord, that 2020.
There was no financial crunch in July 2020. The person,
that is my submission. July 2020.
there was no financial crunch. At that time, no decision.
Was like me. Because he was the earlier.
I'm not saying of this petitioner.
Yes.
For the entirety of the, for the entire district. So nobody suffered loss.
No, man.
There was no necessity to renew. But in 2022, their necessity cropped up for extension.
Kindly consider that, my lord. Because, my lord, it was the period about to be ended. So he had not suffered such loss.
When period about to
My
be
lord,
ended?
March, my lord, COVID hit.
March of?
March of 20, after 20th. 23rd March, our High Court remained closed. That is from 30th March or 23rd March, 2020.
Of 2020.
2020. That is I am saying.
2022, it could not be, no auction could be. I am on 2022, not on 2020.
I am on 20.
But, you are very active. In July 2020, your authorities could hold auction when everything was closed.
My lord, kindly.
Everything was closed, Ms. Bhattacharya.
No, July, my lord.
All lockdown, courts were running in truncated form, but your authority could hold an auction in July 2020.
My lord.
You are very active.
No.
I'm not saying about you.
That
The-
I have understood.
Yes,
But my lord,
because now you are not state.
no.
So,
But my lord, that is, my lord, because of their lease period was about to be ended. My lord, so they had not suffered.
2022 also, your lease period was about to be ended.
That he has not.
All
made
right.
the prayer.
Any judgment you want to, any decision you want to
My lord,
cite?
yes, I am giving, my lord. He had not
Cite the
made the prayer.
decision.
And my lord, the
All right,
second
all
is
right.
that 2 months. And
I'm not on that, I am on this, yes.
I have
So-
suffered, my lord. Here, my lord, the admitted amount I have stated. And my lord, if that is so, subject to the payment of such amount, my period may be, my lord, taken away from me. That is, the Jila Parishad may be directed to pay the admitted amount.
Yes, yes.
Which I have annexed all.
Has
And my
to
lord,
be.
that is. Yes. কোনটা একটা কপি আছে বইগুলো রিকুইজিশন দিচ্ছি
On what point you want to cite judgment?
my lord here judicial review of administrative action
Policy decision cannot be interfered with. You can give the decisions and the paragraph numbers.
arbitrary
Policy decision in judicial review cannot be interfered with.
exclusion of judicial review contractual transaction of government and my lord expert body and my lord policy decision policy matter
Yes, I'm saying policy decisions cannot be interfered with under judicial.
of the government is also excluded.
Contractual,
The exclusion of judicial review, contractual transaction of government. That is my lord 2022-6 SCC 401.
2022-6.
Yes.
You have not brought the 2024 judgment.
No, my lord, that is not.
That considers everything. That carves out an exception in what cases the court can interfere. Kindly show that judgment.
Always, my lord, the court has the
Since
power.
you are relying upon this judgment, the exceptions have been
No,
carved out
my
in
lord,
2024.
Yes. And my lord, another point is that.
Yes,
that
yes,
is, my
give
lord,
the judgments.
my lord, 3 judges when judgment I am giving because it was
What is the cost title?
cost title, my lord, Rajiv Shuri. That is, my lord, that change in policy decision is well recognized as the function integral to governance. So, my lord, whatever the change of policy, 20 auction was issued, auction was called for, and my lord,
Have you brought those decisions which says that state largesses cannot be distributed by way of extension, has to be by way of public auction? You have not brought those judgments.
that is my.
You have not brought those judgments. Yes, yes.
I cannot, my lord, it is.
Why cannot? You have to show both the judgments from
my
both
lord,
the
that is
sides.
the duty of my friend, not my duty, my lord.
Yes, yes.
My lord, this is a very long judgment, my lord. I have not taken the print. 2022-11 SCC 1.
2022.
Volume 11, SCC 1.
How many decisions you want to cite? Don't multiply decisions on same point.
Sir, my lord,
2022.
wait a minute. 2022, volume 11, 11. Paragraph,
SCC,
SCC 1, my lord.
page 1.
Page 1.
Yes, paragraph.
Paragraph, my lord. Here it is 197, 202, 204, 206, and 483. Here, my lord, it is
204 and 483.
483, 204, 206.
Yes, and 483.
My lord,
Yes.
483.
Yes.
না 197 টা যেটা লিখেছি 197 টা দেখে মানে be it noted that the 197 be it noted that the constitution provides an effective mechanism to review the law itself under which administrative power is being exercised for the law in the expression rule of
Give
law.
me the decision. Let me see.
My lord, it is a very big, that is one of Parliament House. And my lord, in which case the government decision considering the economic factor that may not be. And my lord, in pandemic situation যেটা দিয়েছি সেটা দে এই যে যেটা pandemic situation এ দিয়েছি policy decision pandemic 2021 volume 9251. Well, I have not done any fault. So I am being penalized. I have incurred expenses. That kindly consider that issue. And if the Jela Parishad is directed to pay the expenditure I have made, then my lord, fresh auction may be called.
Your client did not agree to that.
No, my client, my lord, it is
That
agreed.
is why,
Additional amount.
Or-
If it is fresh auction,
Bhattacharya, if it is cancelled from today, let us assume.
Yes.
According to your submission, if that expenses is paid back to you, they can hold an auction.
yes.
So let us assume that you participate in that auction. You may or may not have to
I
pay
guess I
the
can say
excess
that.
amount. But your client, that is why I wanted that affidavit from your client.
Yes, my lord, excess amount because of my lord, what he will be. His declaration was that what he will
That
be,
is,
he will be more.
Yes.
And my lord, what he will
He will
be,
be quoting that amount in the auction.
not auction, my lord, before your lordship.
Yes, yes.
If your lordship is called for the fresh auction,
You have no problem.
problem. I may
Shall I
participate.
record that?
I may.
Shall I record that? Fresh auction, you do not have any problem.
My lord. It may not be. It is his prayer. If it is allowed, it may not be, my lord, recorded. If it is allowed, it is up to your lordship. Your lordship may cancel the tender just from next month or this month or henceforth. Then, my lord, the obvious outcoming will be the fresh auction. And my lord, I will be also free to participate there, and all the public will be free. His submission is, his prayer is also that open public auction should be called.
Yes.
My lord, if it is called, I am the legitimate claim to
Yes,
get
yes.
back that.
You will be entitled to participate.
No, my lord, upon payment, Jila Parishad can do that upon payment, subject to payment of the admitted amount. I am not claiming, my lord, compensation damages. That I will go to suit.
Where is the admitted amount, Ms. Bhattacharjee?
My lord, admitted.
Show me
given-
from this. Who has admitted this?
My lord,
Accepting that lease rent, nothing is admitted.
given all the bills. That may be hard out.
Bhattacharjee, don't use the expression admitted. You are saying admitted. Admitted means they have admitted. Where is their admission? It's your claim. You can say that what I have spent. Don't use the expression admitted. It's not admitted. And no,
My lord,
maybe that does not mean since you have a,
the authority.
yes.
But my lord,
So
from
they are also, in order to make a claim, it's not that he will make an exorbitant claim. They will have to be, you have to be paid with that amount
let it be
as a
checked.
condition for cancellation.
Let it be checked by the authority that whether it
Yes,
is
yes.
stated or
For
not.
that, the period you will be entitled to, subject to proving the expenses which you have incurred for that period. For the balance period, for the forthcoming period. Past period, what you have done is done.
My lord, I cannot get my lord.
Was there any permission from was there any permission from the Jila Parishad?
Yes, Jila Parishad can answer. Yes, my lord. Whenever on the flat, এই তো বন্ধ ছিল যে
Settle it out with the Jila Parishad.
No, my
Settle
lord,
it out with the
my
Jila.
lord,
Any other decision you want to cite? Ms. Bhattacharjee, then you have to give copies of this.
Yes, my lord, it is a very lengthy judgment, my lord. Moreover,
Want to rely upon, you have to give copies. Yes,
your
yes, yes. Next.
my lord, and my lord, that is একুশের নয় না তো? হ্যাঁ, একুশের নয় 251. Yes. এটা আছে।
Yes, you need not press this judgment. I have seen that. Give copy of that judgment. Yes, next.
My lord, para 48, 49, 53.2.
Yes.
My lord, 48, 49.
Yes, the paragraphs which you have cited, I have noted that.
No, my lord, it is of my lord 2021.
Oh,
Nine.
another decision.
Another decision.
2021.
Volume 9, SCC 292.
Yes.
Volume 9, SCC 251.
251. Yes.
Here, my lord,
For what proposition?
my lord,
Paragraphs.
paragraphs 48, 49, and 53.2.
Yes. For what proposition?
My lord, it is the pandemic situation. The policy was taken for that. 48.
Ms. Bhattacharjee, there is nothing on record to show for pandemic. This was done.
Yes, my lord, that is.
Show me that from the records.
That record is with the Jila Parishad.
Yes.
I am not, my lord, with
Yes,
that
yes.
record.
Do you have,
That
then,
resolution,
then how can you say that was for pandemic if you have no document with you?
my lord, I have placed that I have suffered loss and that they consider.
That is your prayer.
Yes.
Yes.
And that they consider.
According to
What-
you, the policy decision was for pandemic. You have no documents to show.
My lord, that is, my lord, that for pandemic period, no meeting could be held. That has been recorded
Yes,
in the resolution.
that I've seen.
And for that reason, my lord, it was extended at the rate of, my lord, wherever, my lord, 15%.
That I've seen, but not pandemic. For pandemic, that was extended. That is
My
not
lord,
here.
that may be their file, their recommendation, everything, where the note was prepared. My lord, in the resolution, it was that the first, this situation, meeting could not be.
All
held.
right. Yes.
No meeting. My lord, here 48.
Yes.
83.2. The appropriate authority is directed to issue simplified guidelines for issuance. No, it is not that. 49. We have gone through the details. However, we feel that the procedure should be simplified as it can be. Therefore, a simplified procedure guidelines are required to be issued by the central government and/or appropriate authority for issuance of an document, death certificate, etc. That is, my lord, the benefit given by the authority.
All right, what is the next decision? Give copies of this.
Yes. And 20, the আটেরটা দিয়ে দেখি। একুশের আর 511 ওটা দেখ কি হলো, এটা কি হলো 511 মানে 2021 volume 8 SCC 511 here, my lord, the case is
511. Paragraph.
It was not given, which was challenged.
Paragraph.
Paragraph, my lord, 78 to 86.
Yes.
And my lord, 78 to 86 and 99 to 103.
Yes. Yes, on what point?
Here, my lord, the policy decision was taken, waiver of interest, the government has not given so, that has been challenged, and there it has been held, to some extent slightly different from me. They are held that economic, after considering the factor, whatever the decision has been taken by the executive authority, that cannot be intervened. But here they were claiming some benefit which was negated by the authority.
All right. Anything more?
No, my lord, not anything more, my lord. I am.
Give copies of these judgments. Yes, anything in reply?
And
I'm relying on that very two spectrum order, my lord. It was passed on 2 dates, one in
yes,
10,
my lord, that
one
is
in 12.
his judgment.
Yes, yes.
Lordship,
No, let her distinguish your judgment. Yes.
Yes, my lord, here, the first paragraph, petitioner has moved this, my lord, the Kausar Ali, it has been. The petitioner had moved this court on an earlier occasion by filing WPA 5263 of 2022. By an order dated March 29, 2022, the court directed that the prayer for the petitioner before the authorities to grant extension of lease to operate the ferryguard after the period had expired is considered by the authorities sympathetically. Here is also case, what has been he is submitting. Such prayer for extension of lease on the was made on the ground that although the petitioner has deposited entire rent, losses suffered due to pandemic situation.
So this was also the ground paid for
No
extension.
record was that. It was only the submission.
Yes,
No
yes.
record.
Prayer was made.
Yes.
Prayer was made for consideration of the prayer for extension
Yes.
sympathetically on the ground of pandemic situation.
So praying so.
Yes, yes. Now what the court has heard.
Yeah.
Whether it was allowed by the court or not.
Accordingly, the petitioner representation was decided. The petitioner was granted a hearing. The written statement was filed by the petitioner. And then, my lord, the executive officer of the Raghunathpur 2, that is, my lord, the
Murshidabad Jila Parishad.
Raghunathpur, my lord, it may be, my lord, Purulia. Purulia also, Raghunathpur is there. Purulia. Raghunathpur 2, everywhere, my lord, it has been extended. Even, my lord,
Yes.
IRCTC stall lease was extended.
What happened after?
The executive officer of Raghunathpur 2 Panchayat Samiti, by an order dated April 11, 2022, express intention of the Panchayat Samiti to hold open auction for granting lease of all 6 ferryguards.
So that was in 2022,
Yes.
April.
Yes,
And you are,
I am also 2022.
yes, June, decision was taken.
Yes. Same.
April, your decision to extend, here no, auction.
The matter
Within the same state, Ms. Bhattacharyji.
Yes.
One Panchayat Samiti says auction will be held. Yes, yes.
That is different. The matter was under active consideration of Ortho Unnayan.
And what did the court hold? To grant extension or
Yes.
to go for public auction?
Here also, court does not find, my lord, the page number is not there. The my lord, beneath it is 3. Heard the learned advocates for the parties, this court does not find the rules with regard to settlement of ferryguard and the circulars issued in this behalf permit continuation of the operators after expiry of the lease.
Yes. No rules?
No, no rules is there here.
Yes.
So my lord, whenever my lord, that has been, I have categorically.
Then
stated.
proceed. You are distinguishing.
Yes.
Proceed.
Petition, that indefinitely I am not claiming.
No. What is the distinguishing feature in this judgment?
Yeah, this is a
Point
policy
out that-
matter. My lord, this is a policy matter and entirely within domain of executive.
Yes.
It has.
Next paragraph,
Yes.
page 4, top is very important.
Yes,
This
my
court
lord.
is of the view. Kindly place that.
This court is of the view that when the Panchayat Samiti has decided the ferryguard should be settled by public auction and issued auction notice of auction, such policy decision cannot be interfered. Policy decision cannot be interfered. Here, auction was
Next paragraph.
transparency and maximization of revenue by allowing all eligible
Yes.
persons to participate in such tender is the correct method. My lord, I am not disputing so also.
Ms. Bhattacharya, do you want to say the courts cannot interfere with any policy decision?
So that when there is arbitrariness,
Yes.
that is reasonableness,
So next paragraph, court qualifies that.
the court does not have
Why the
any
court is not interfering with the policy decision? That has been qualified by the next sentence.
the court does not have any authority to either set aside the auction or to hold
By the same
policy.
coordinate bench.
Yes. My lord,
The earlier one also.
my lord, the situation is different from different.
Yes.
Here, auction was
Yes.
held. So that is the policy decision. Here auction was held. That was the policy decision. Here auction was not held. And my lord, judicial review of administrative decision is permitted only when the decision-making authority does not act in accordance with law. Here there is no law, so does not act in accordance with law, does not arise. There is no rule. All the rules and my lord, the finance guidelines also in respect of where the expenses are to be made by the government authority or the constitutional authority. Where they are earning, there is no such notification. In the matter of Tata Cellular and Union of India reported 1994-6-651, the Honorable Apex Court laid down the following principles with regard to judicial review of the administrative action. The modern trend points to judicial restraint in the administrative action. The court does not sit and court of appeal. That is, my lord, my one point is also there, that whether the profit might have been more or might have been less, that, my lord, is the best judge, is the authority. They have enhanced 15%, considering that. So the court does not have the expertise to correct. That is why I am relying upon, my lord. The administrative decision, if a review of the administrative decision is permitted, it will be substituting its own decision. That Tata Cellular decision I am relying upon, my lord. Without the necessary expertise with itself, it may be fallible. My lord, 2022, whether more may be got or not, may be obtained or not by the authority, that is up to their consideration. They thought so, that that is my lord logic. I do not know what the authority, that after facing such kind of loss, mishap, may not get that kind of bid. So they have enhanced 15% totally. And my lord, totally, my lord, 20 to 22, it has doubled, my lord. I have deposited 21 lakhs like that. Here, my lord, 41 lakhs. The terms of invitation to tender cannot open to judicial scrutiny because of invitation tender is the realm of contract, which I submitted, my lord. The contractual matter of the government is outside the judicial review, my lord. It is the settled law, my lord. Normally speaking, the decision to accept the tender or award, here not, my lord, the tender or nothing. Here the auction earning is involved. Here not the expenditure is involved of the government. It is my categorical statement I have given. Normally speaking, decision to accept tender or award contract is reached by the process of negotiation through several tiers. More often than not, such decisions are made qualitatively by experts. The government must have freedom of contract. In other words, a fair play in the joint is necessary if administrative body functioning in an administrative sphere or quasi-administrative sphere. However,
So you are not distinguishing, Ms. Bhattacharya, you are relying on all the paragraphs of the judgment.
that is in my
Which part you are distinguishing?
decision. That is, my lord, if it is against the public policy, the last page.
Yes.
In the decision relied upon by Mr. Rai in support of his contention, namely Kannanji Group Shamiti and others, State of West Bengal passed in such and such 2851 of 2005, the court finds that his lordship has categorically held the prayer of renewal of lease and extension of the period would not be granted if it is opposed public policy. Here, my lord, I am relying, it is not opposed public policy, it is rather for the beneficial effect for the business community, not me only. It is the public policy because business
Public policy means for a particular community or the public in general.
business, trade and commerce is the public.
Yes, but it's
Yes.
for only for a particular community or
That-
for the public at large.
21 words which I have relied SCC, that my lord, my lord, whenever government is giving some benefit, it is giving a benefit to a group of persons, to a community, not as a whole the entire public. Whenever a benefit is given to a community, my lord, exemption of tax and everything, all of us cannot get that. Who are entitled, they will get.
Yes.
So whenever, my lord, this extension of lease has been granted, then, my lord, it was for the whole, not any undue advantage given to me. It was for the whole, considering the revenue they have.
Anything more?
My lord, notice. And, my lord, I am relying on, my lord, that is also I am relying, my lord, 1994 6 SCC 651.
1994?
Volume 6 SCC 651. Tata Cellular, my lord.
Oh, Tata Cellular.
Yes.
1994
6 SCC 651.
651.
Yes.
All right. Anything more?
Nothing.
Yes. Anything in reply?
And my lord, my summarizing my submission is that my lord, that is, my lord, I have not gone any malafide intention and anything. And if the Jela Parishad, if the fresh auction is directed to be held, my lord, then, my lord,
The amount which you have spent, that has to be refunded.
lordship is considered that the rent is the admitted amount, whichever your lordship is pleased to consider the admitted amount.
No,
That-
Ms. Bhattacharya will not get any admission here.
My lord,
Because
that is
this
the-
is-
that is the documentary.
That is, no, rent is
Rent is,
admitted.
this rent
Rent is admitted. The other expenses is not admitted. That is your claim that you have made those expenses. So
the rent is totally
rent is admitted.
that may be returned, my lord.
Yes,
That's
yes.
refunded.
Yes, that has to be.
That is
That has to be because you have paid for the entire.
also suffered. That is also my claim. The business loss
That
damages.
that is subject to proof.
Let the Jila Parishad be, my lord, directed to give a hearing for that.
Yes, yes, yes. For
That
that,
if- But, my lord, I am willing to extend this after that, my lord, because I have already suffered the last 2 years. Then for compensate that it has given, and then also I am making.
yes, yes.
My lord, I'm just,
Not on facts, only on the law point. Don't
Only
speak
law
on
point,
facts.
if I am the executive officer or additional executive, I am supposed to carry out the decision of a certain body. If they claim it is the policy decision, then there should have been the thorough analysis after which some decision can be. The pros and cons, the revenue portions, public utility, sufferings, all these things. There is no such considerations. I being executive, I am supposed to carry out the decision of the governing body. There is no decision. On my own capacity, I have extended. Then I am influencing the body. You please come with extension. And in the extension, I am passing the order in 22nd April. Term is to expire in 29th July. In June 6th, they are coming with a decision, and this is that all the expired decisions that can be extended. In this decision, my issue is total silent.
Yes.
So naturally, my lord, this is a whimsical approach on the part of the executive officer or additional executive officer, who is the bureaucrat there. He is not having that power, and he is not the policy making body. He is not the governing body. Naturally, he is his extraneous power. He has exerted.
Yes.
And there is no, and as far as the pandemic issue is concerned, my lord, there is no policy decision as far as the government of West Bengal is concerned that the all tenders should be extended for this reason. There is no amendment in the rules. There is no statutory, there is no notification, nowhere in this. And my submission was that, my lord, if it is 15%, why not it is the minus 15%? If they have lost, if there is a consideration, then that could have been minus 15%. My lord, this is the 15% or 150%. This is not the issue. Issue is the whim. Whether the public property can be discharged to a certain favor. If this is the approach, if this is the thing, and this is the illegality, this is the unreasonable, this is the arbitrariness. This strikes at the very root of the Article 14 of the Constitution of India, my lord. I am relying on the judgment of the basically on two spectrum only. 2 days that judgment was. 1 in 10, and after thought is there, CAB was asked to go through, then CBI and all these things. I am just giving one example, my lord. It was then in 2 spectrum case. First come,
This
first
judgment you
come.
have relied upon when you were arguing.
Now, that is what the ratio was fixed.
Yes.
But here, my lord, third party interested was created. Tender was invited in 2008 itself. It was challenged in the same very year. Then came the issue, CAG report, CBI, all these things. And preliminary hearing was held on
The reference.
Yeah, I'm giving the copy of judgment, my lord. Which same judgment? I'm just giving page 20, my lord. Ek minute. Ek minute. Page 20, my lord.
Page 21, yes.
Page 20, my lord.
May I get the, my lord, the reference?
Son,
reference দেওয়া আছে।
কোথায়?
বুঝেছি, দেখ।
reference is not here. This is the downloaded copy.
Yes, my lord.
Yes.
My lord,
Give him a copy. Give her a copy.
এক minute.
Yes, page 21,
Page 20, my lord.
page 20. Yes.
Soon after obtaining the license, paragraph, my lord.
Yes.
32. Soon after the obtaining of the license, Swan Telecom, which had paid license fee of 37 crore,
Yes, yes.
immediately offloaded 45% of share to Etislate for 4,500 rupees. See the profit, my lord. Then Unitech, which was obtained license in 1651 crores.
Yes.
They uploaded 60% at the 6,120 crore. See the profit, my lord. And it was the report of the CAG that there was a defalcation of around 1,76 crores. I'm not going to that point. My only submission is third party interest was created in 2008 itself. Then it was totally, entire process was cancelled without any compensation. And this has been the policy that largesse of the government cannot be distributed in a whimsical and capricious manner. There should be a wide, transparent, and the things that has been Honorable Justice Shamba Sarkar that has relied on in her judgment also.
That is the well settled proposition. There is no dispute with regard to that. What she is trying to canvass is because of the pandemic situation, this policy decision was taken. Whether the court should interfere with that, that is a submission.
My submission, my lord, if issue is pandemic, Lordship has already observed in that point. If it to 2020 tender could have been arranged, and it was close to July 30.
Repeat those observations. If you want to rely upon that, don't repeat those observations.
My problem is that
Also, don't rely on those observations because those.
Lordship, my submission only on that point, my lord. In the August 2020 itself, I made a presentation to the authority that you please, I'm in dark whether you are not calling by inviting tender. Your tender has just closed. You please go for a white tender. And it was received on 25th August itself, 2022.
No reply given.
No reply given. Then I made a further submission on
right.
6th September, my lord. No reply given.
When can you
Then
take
I came to
decisions?
if these are the representation remain and my lord, this is their submission, this is their admitted position.
Yes.
If the representation is made, that should be replied to and looked into. They remain silent with all my
All
prayers.
right. When can you give those decisions? Copies.
মানে by Monday?
Monday.
আজকে Tuesday, Thursday.
Yes. Xerox will take 5 days.
No, my lord, tomorrow.
My only my
30.
Tomorrow, by tomorrow, my lord.
4:30.
my lord.
Judgment. That is, my lord, the SCC 1, which is the 2022 SCC 1. My lord, that is of, my lord, 483 paragraph, my lord.
You are thinking of that. Your junior must be thinking of that.
My lord,
Not think of that.
my lord, only submission, my lord. Their gainful position at the serious detriment of the
All right,
government
you need
revenue,
not
my
give
lord.
that.
Any decision, lordship, make it
Xerox
to
don't
pass
take time.
today, my
You
lord.
have to give that judgment. Accepting that, give the other by 4:30 today.
হ্যাঁ ওটা ঠিক আছে, ওটা পাতা করতে ওদের টাইম লাগবে।
কোভিডটা
Give the first judgment, you need not
ওটা বলে দিলে
give copies of that.
কোভিডটা তো কনসিডার করে
So yes,
10
book
লাখ
are returned.
My
One
one,
not kept any book.
my only,
It's his book of Panchayat manual.
lordship, my just
Ashok,
time, lordship, my just time giving one page reference, my lord.
heard the learned advocates for the parties.
May I just submit, my lord, one
Uh,
submission, my lord? They had made the COVID
Hearing
situation. This is
stands
their analysis. 30
Judgment
lakhs
stands-
became 10 lakh, my lord.
Judgment stands reserved. Acha, তার আগে করে-
Your lordship is not sitting. Tomorrow your lordship is not sitting.
that I don't know. Give it by today.
No, my lord. If
Don't
it
wait
shows
for
that
tomorrow.
May give it, give that also.
Judgment might appear tomorrow. That is why. Give it by 4:30. You are not giving those copies, I could not dictate now. You will get the decision by tomorrow.
Well, your
will be
lordship
in
is
the-
convenient, my lord, to operate the laptop or everything. Well, I know, my lord, your lordship is very convenient. With my lord.
আসুন, আসুন। Yes. করে দিয়েছেন তো? Judgment, তার আগে লিখুন। Heard the learned advocates for the parties,
But
full stop.
যেগুলো দিদি
Ms. Bhattacharjee, learned advocate appearing for the private respondent submits that the photocopies of the judgments relied upon by her in course of the argument, in course of her submission shall be supplied in course of this day. তারপরে hearing stands concluded, judgment stands reserved. Yes, next.
Lordship, grateful lordship.
12
I have also filed the recalling, so it may be also dealt with by your.
The main matter is decided. আচ্ছা, ওইটা একটা করে দিন। You have filed a supplementary affidavit.
Of the recalling also, that additional amount I am not paying.
So you have filed a supplementary to the writ petition.
Writ petition
The
and supplementary to the
affidavit,
recalling
that
also.
record করে দিন, the supplementary affidavit filed by the private respondent as well, supplementary affidavit in connection with the writ petition filed by the private respondent as well as the supplementary affidavit in connection with the recalling application filed by the private respondent are taken on record. এটা একদম উপরে করে দেবেন।
Yes.
তারপরে
I am
My lord, we have filed an exception to the affidavit that they have filed, my lord, in terms of your lordship's order. my
all right, exceptions টা taken on record করে দিন। Today you have filed.
lord.
Submitted.
Yes. Yes,
My lord, if my lord,
every day.
every
is-
day at the fag end, I'm getting the opportunity, your lordship.
This is the problem.
My lord, on the last, if my lord, may I just in brief summarize what I have
You need not
submitted?
repeat. I remember you can proceed
lord,
from where you stopped yesterday.
Your lordship, I was placing my reply to the charge sheet, my lord, that is at page 40 of the writ petition,
40?
of the writ petition,
Yes, 40.
40. This is to humbly submit that I, force number such and such, Shushanto Kumar Bokshi, want to make statement against the charges mentioned in memo number such and such dated 10th of June 2020 of your office, which is the reflection of the incident between me and force number such and such, Gora Chat Shamui, occurred on 1st of March 2020. I, force number such and such, Shushanto Kumar Bokshi, was on duty as sub-inspector in Central Reserve Police Force in 3rd Wireless BN Head Office on 1st of March 2020. From the morning itself, I was busy in connection with the function to be held for the governor. My lord kindly notes this.
Yes.
In Chengel, Howrah, from the very morning for arranging for the goods with Inspector Crypto BB Singh and Head Constable Shomir Das, 3 Signal. Along with this, I was looking after the arrival of the personnel of the force posted in Bengal. During that time, at about 12:30 hours, force number such and such, Gorachad Shamui, and force number such, Havildar Shunil Kumar Shumon came to me near Men's Club and force number such Gorachand Shamoi started telling that force number such Sunil Kumar Sumon behaved indecently with his wife. While seeing the behavior of force Gorachand Shamoi, it appeared to me that he was under intoxication. While as the condition of the personnel was not right, I persuaded him to go back because of my busy schedule, and failing that sending the goods and the parties, I would talk regarding the same. However, the personnel was not agreeable to accept the same, and being angry used unparliamentary and indecent language to me, mentioning my such, my lord has seen that. I was astonished seeing.
You want Mr. Majumdar to take over? Yes, Mr. Majumdar. Every day when she is starting, only 5 or 10 minutes left.
Today,
Because-
I have. Today there is a.
There is also same thing, 1 p.m.
Oh, today there is another one.
Yes, yes.
Not scrutiny of evidence in exercise of judicial review in respect of a disciplinary proceeding is normally not done. Although, my lord, in a very recent pronouncement, the Honorable Supreme Court has observed that depending on fact situations of case, the writ court can also go into disputed questions of fact if it is worthy of doing so.
So those are the exceptional cases.
Exceptional cases. But normally in disciplinary proceedings, there are two restrictions which are imposed on writ courts. Number one, scrutiny of evidence, and number two, sitting in appeal over punishment. Because that is the wisdom of the employer or the punishing authority. Only exception is if the punishment shocks the conscience of court.
Disproportionate, shockingly disproportionate.
Shockingly disproportionate. And what is the arena of disproportionality to be considered? That goes into the aspect of the attending circumstances to a small extent. Your Lordship will not have to scrutinize evidence, but what was the nature of charge and what ultimately happened? And what is the severity of consequence? Severity of charge.
What is the punishment in this case?
Compulsory retirement.
Compulsory retirement.
Gravity of charge with the severity of punishment. These are the guiding factors for determining whether it shocks the conscience of court.
It also depends upon the nature of the duties,
right?
The position which he is holding.
Gravity of offense, charge. Gravity of charge.
The same charge may not be a compulsory retirement, may not be imposed upon person holding a post X, but that punishment can be imposed a person holding a post Y.
In one of the judgments, the Honorable Supreme Court used the expression parity in punishment in the case of co-delinquency.
Yes.
Parity in punishment in case of co-delinquency is a test of proportionality. Now, what I may do as an employee may be condonable, but
yes, another employee it may not be condonable.
Superior officer, for a superior officer it may not be condonable.
Different, because discipline force, it may be one grade of punishments which can be given.
Here is a case where your Lordship's court is dealing with an incident between a constable and a sub-inspector. Admittedly, on record, the constable was under intoxication at 1 o'clock in the afternoon. The sub-inspector was preparing for a dignitary to come. He was busy in his duty. The constable came and said that other constable had said something to his wife. And he wanted my client, the sub-inspector, to take action against the perpetrator of wrong. To which I said that, why are you disturbing me? And there was that incident. The complainant, the subordinate, he also landed a blow. My client also landed a blow. He missed. I was more perfectionist.
Any proceeding against that person?
No. Not he challenged his inquiry somewhere else. Not only there were 2 eyewitnesses.
No proceeding initiated against him.
Nothing. Nothing. Huh? there was a summary proceeding against him wherein he has not been punished. Not two things may appeal to your lordships. Not one, please come to page 243.
243.
Yes.
Yes.
But this is part of the inquiry report. Assessment of evidence in the inquiry report.
Yes.
Please come to paragraph 4, the last paragraph on that page. As per the question number 6 put to force number so and so, Krishna Bahadur Singh, in his cross-examination made by the charge-sheeted member of the force, when Constable Gorachand Shamui was in the quarter of commandant, during that time he was under intoxication.
Yes.
Now, please turn back to page 240. He was prosecution witness number 2, the most important, one of the most important witnesses. Gorachand Shamui, the constable. As per the, it's just above paragraph number 1 on that page. Please see Roman II. As per the statement, question, answer, and cross-examination done to prosecution witness number 2, Gorachand Shamui. Force Gorachand Shamui on 6/7/2017 had come to 3rd Signal Battalion on being transferred from so and so. On 1/3/2020 at 11 AM, his wife Shravani Devi, he and his wife went to the then adjutant for making complaint of misbehavior turned to his wife Srimati Shravani Devi, who was at the time near the men's club.
Yes.
Somebody else had made certain gesture or not disturbed his wife. When force Gorachand Shamui went with his wife for making complaint regarding the teasing made to his wife and made complaint before SI Sushant Kumar Bokshi, the petitioner, then instead of hearing his complaint, he told his wife as characterless and said that what had happened to that, you go away from here, and he told them to leave place and told that he did not have time.
Yes.
Then what paragraph 4 is the abuse.
Yes.
And then after that abuse and served blow on him and the person present belonging to ROBC as per the order of SI Sushant Kumar Bokshi caught hold of him. His wife, seeing the incident of beating and assault, was terrified and requested SI adjutant not to assault her husband and let him go. He abused his wife and also told him to leave the place, and Havildar Gajanand Sharma, who was present there, he was told by the adjutant to confine him in the quarter guard. So this is the sum and substance of the incident as per the complaint.
Yes.
Gorachand Shamui went to quarter guard with his wife and their daughter, where the Havildar Hawa Singh took them inside and made them sit in a room and started locking in a room. When his wife informed that he was carrying, he did not should be crying. He did not confine them. Constable Shamui, going to the quarter of commander, informed about the entire incident, and the commandant sent him in MI room for medical. The MI, after giving preliminary treatment, sent them to BSF Joint Hospital for treatment. The incident of the treatment done in the BSF hospital, Gorachand Shamui, 4 copies of X-ray report were placed. Constable Shamui, in reply to question number 6, stated that when the SI Hawa Singh took him to his quarter guard, seeing blood on her face, should be his face, told her wife to clean his blood. As per the statement, question, answer, and cross-examination, witness number 3 of the prosecution witness, Veer Bahadur Singh, it goes on like this. Please come to paragraph 3, page 243 I have placed.
Suffered some injury.
Suffered an injury. Not a blood clot, that's what this is.
Yes.
Now please see the defense version at page 252.
252. According to you, you also suffered some blows, but nothing serious.
Not both of, there was a scuffle, maybe, not the person who succeeded suffered the punishment.
Yes.
As per the statement, this is not a question of dereliction of duty. It could at the most be a conduct becoming of a government.
Assaulting your fellow member.
But I'll show to your lordship the charge.
You're a junior.
I'll show to your lordship the charge.
Yes.
But what is evidence? Evidence is the missing link between the charge and the finding. Page 252.
Yes.
As per the statement and question and answer of defense witness on behalf of the charge sheeted personnel, Sunil Kumar, force so and so came to head office on posting on 20th. Kindly skip over that page, paragraph 2. On 1/3/20, he was in charge of men's club. During that, Constable Gorachand Samui misbehaved with him. Then he, while informing about the said incident to Havildar Samir Das, who was during that time BHM, he was hurling abuses. Then upon this, BHM told both of them for going to Sushanta Kumar Bokshi, and both went to Sushanta Bokshi Sahib towards the men's club. Constable Samui, even after going to SI administration, was hurling abuses. Then I thought that he was under intoxication, and when he wanted to say something, he did not allow him to say the same. When SI admin tried to pursue him, he started hurling abuses at him. So this was a case of provocation. And also start beating and assaulting him and lays his hand on him. He wanted to go near Constable Gorachand Samui, then he landed boxing on him, upon which he went away from there and started doing his duty. As per question and answer, when wife of Gorachand Samui was asked to go out of the recreation room for the second time, he muttered something, went outside them, and when Gorachand Samui by phone asked him about sending his wife outside, he told that there was no order for any lady to stay there, upon which he started misbehaving with him over phone, then he cut off the phone. In reply to question number 3, Sunil Kumar said that the Constable Gorachand Samui hurled abuses at Sushant Kumar Bokshi. In reply to question number 4, Gorachand Kumar said that Gorachand Samui lay hand and leg on Sushant Kumar Bokshi, as a result of which he fell down on his eyeglass, fell down. However, he did not know as to whether he sustained injury. So these were the conflicting or evidence and contra evidence laid in the disciplinary proceeding by eyewitnesses. What happens? What would be the immediate reaction when a subordinate lays hands on a superior? As a member of a disciplined force, do I give a salute to him? Or teach him, no, you should always stand in the saluted position in front of me. Now, subordinate in intoxicated condition laying hands on a superior who goes scot-free. And the person who reacts to the provocation suffers a major penalty. One of my clients, I had been to an army.
What was the nature of injury suffered?
There was a blow landing on the face.
Yes.
There was possibly a small clot on the. There was a bleeding from the nose and a clot in the eye, which was, of course, redressed. But there is no evidence that he had to be hospitalized or take leave for this purpose.
Oh, he did not take also leave.
It doesn't appear from the records. One of my clients, I had been to an officer's mess, in Delhi. I had been to accompanying him. And I found that there were only 2 guards. I said that this is they are all high-ranking military personnel. What happens if somebody enters into this with there is a possibility of attack and everything? He said that if he can't protect us, how can we protect the nation? If he can't defend us, how do we defend the nation or the sovereignty of the state? Number a subordinate in intoxicated condition at 1 o'clock in the
your
afternoon
stand is that while defending myself, this has happened.
And this is a normal human behavior for every individual, whether he is a member of a force or not.
That was in self-defense you did.
Self-defense and please see a subordinate trying to assault an superior in inebriated condition at 1 p.m. in the daytime. And what was he doing? He was preparing for a dignitary to arrive. He was preparing for the occasion. My client.
Not 2 p.m., Mr. Prajita, how are you placed? But subject to that, any matter in the division bench.
I shall take a chance. That is where the conscience should be.
বলা যায় না ডিভিশন এর ম্যাটার আছে কিনা কেউ জানে না। ভালো হবে। এখানেই থাকে, এখানে দুটোর সময় হতে পারে।
Matter, my lord. My lord,
Not now,
earlier
yes.
mentioned, your lordship has been pleased to allow the mentioning.
This is not the mentioning time.
Also present. 19 minutes. Service matter, so there's,
For hearing,
yes, I'm appointed from.
not now. Wait for some time. Yes, call the list.
Item number 12, continuing matter.
Larger bench, larger bench, 2 PM, my lord.
Larger.
আজকে না
This happens with busy councils. They do not get time to go through the list.
তুইও তো এসির বল না।
Yes.
My lord, Lord, my senior was placing page 243
Yes.
of the inquiry report, your lordship.
Yes.
Lord,
Yes. 243 was placing those evidences.
lordship. Thereafter, your lordship, if my lord, may I take your lordship to page 245?
Yes.
My lord, this is the statement of Gajanand Sharma.
Yes.
Force number such and such, Gajanand Kumar Sharma, on being transferred, came to third signal, such. Now, my lord, the second paragraph. According to question and answer of filed asked to him by Gajanand Sharma, he received the information about the quarrel between Constable Gorachand Shamui and Shushanto Kumar Bokshi at 2 hours. Now, my lord, the second page, next page, my lord, 246.
Yes. What you are trying to show from this?
My lord, what I am trying to show you, lordship, my lord, the evidences that have been relied on in the inquiry officer's report, your lordship. My lord, there are, your lordship, depositions of the witnesses. Your lordship, those have not been considered. May I just one by one show your lordship?
Yes.
This matter will continue.
That I do not.
Other matter will be released.
No matter is released.
No, my brother told me, yes, that matter will take time.
If they assure you, it's up to them. Court is not giving any assurance.
My lord, if kindly takes up page 71.
71, yes.
My lord. My lord, question number 10. The first question. My lord, this has been asked that what was the complaint were being made by Gorachand Shamui to the commandant. So, my lord, according to him, after being beaten by me, he went to the commandant to make the complaint. Now, my lord sees how he has made the complaint. Sir, my additional duty is being allotted. So he being beaten, and then he goes to the commandant saying that I have been given additional duty, and I am having pain in my vest, and I have been assaulted by Shushanto Kumar Bokshi.
Yes.
I'm sorry, not I.
Yes.
Please come to page 263.
263.
Yes, not I had shown to your lordship not the defense version.
Yes.
Now please come to the analysis of evidence. It begins at 260.
Yes.
But the relevant portion is 263. Since the charge of misbehavior with the wife of the complainant was leveled on fourth so and so Sunil Kumar Suman, should be Sumai. Under this situation, the statement of the said witness appeared to be suspicious. The statement of force, Sunil Kumar Suman, defense witness, and question and answer, he was the eyewitness of the incident from his statement, question and answer, it became clear that the reach up to hurling abuses and beating and assault. However, from the medical reports, it has not been proved that Gurachand Samui was under intoxication and there being no marker.
Is it the translated copy?
Official translation.
Official translation for court.
Please see the left hand initial.
Yes.
Constable Samui was under intoxication and there being no mark of injury on the body of SI Sushanta Kumar Bokshi. As per the medical report, the evidence given by the defense that Constable Gurachand Samui was under intoxication and he assaulted the charged official appears to be doubtful.
Yes.
Along with this other eyewitness present at that time, Srimati Shravani Samui, their wife, it is proved that Sushanta Kumar Bokshi hurled abuse, saying so and situation of beating Gurachand Samui appears. From the statement of the prosecution document, from the statement of the witness of defense party and the cross-examination done by the charge-sheeted employee, preliminary hearing examination that is from the proceeding, it is clear that 4th so-and-so Sushant Kumar Bokshi, 3 signal so-and-so, while working in the responsible post like sub-inspector near Men's Club on 1/3/2020 at about 1100 hours, hurled abuses at his junior force number so-and-so who had come to him to make report regarding misbehavior with his wife, saying so-and-so to become and hurled blow at him and assaulted him, as a result of which he sustained injury on his eye, nose and lip. In this way, the charge in item number 1 of the annexure leveled against the charged employee so-and-so is established fully. Now please come to the charge now. It's at page 33. Lordship may straightway come to page 36. That force number so-and-so, Sushanta Kumar Bokshi, 3 Signal Battalion CRPF, while working as SIA admin on 1/3/20 in front of 3 Signal Battalion at about 1300 hours, as a member under section 111(1) of the CRPF Act, disobeyed the order, ignored his duties or showed negligence in the discharge of his duty. So the charge is of disobedience, ignorance to duties, negligence of duty in the discharge of duty, and misconduct in which he abused.
So, according to you, this first part, there was neither any evidence, nothing. The second part may be some.
But that could be a conduct unbecoming of a member.
Yes. And with regard to causing some injury, that is.
That's right.
So first part, according to you, there was neither any evidence nor any finding also on that. But
apropos the incident, that could not have been the charge. How could negligence be a charge in connection with this incident? How could disobedience be a charge in connection with this? Whenever one enters into the force, there is general order of discipline. Is there a disobedience of order?
That must be some command or direction by any superior or any standing order is there that has been disobeyed. But there is nothing on record to show that.
And third is ignorance of duties.
So according to you, the framing of charge was not proper.
And that's why when I submitted in the first half, that evidence is a missing link between the charge and the conclusion. Now, if charge is X and the finding is something, then not X has to be connected with the finding through this evidence. The charge is of negligence, which is absurd in the given context.
Yes.
This act of the person, then he says that it is abused the member of the force and landed him a blow.
So, and what is so only one charge was proved. So there was only one charge.
But this charge 1 has been elaborated later on.
All right. So there is only one charge.
One charge.
That has been proved according to the inquiry officer. What did the disciplinary authority say?
Now please come to
Disciplinary authorities
just a second, just a second. Just a second. 25th August 21.
Where is the order of the disciplinary?
It's page 1 to 4 of the compilation. It's separately handed up. It was
compilation.
Yes, because not one page was missing at in the brief. One page was missing, so I have prepared a separate compilation with the complete copy of the order. It's running page 281, but not please have a look at the compilation.
Yes, yes. Compilation, it contains the entire disciplinary authority.
One deposition was missed out and the order of the
Yes, the disciplinary authority's
yes,
order,
order,
its entirety is here. Yes.
Should I skip over paragraph number 2?
Yes.
During the course of D, the charged official has submitted an application to this office seeking personal audience of the. I skip over also paragraph number 2. Because I leveled an allegation of bias against the inquiry officer. Why? Because he called 2 witnesses who were not named by the prosecution on his own. So I alleged bias against the inquiry officer. Paragraph 4. The inquiry officer has completed the departmental inquiry and submitted its proceedings along with report. Proved. But I skip over the first sub-paragraph. Please come to the last sentence of that paragraph 4. The disciplinary authority has thoroughly gone through the DE proceedings vis-a-vis inquiry report and observed the following. Statement of 10 PWs have been recorded in the subject DE by the EO, and total 4 documents have been adduced in the DE as prosecution exhibits. Apart from above, one DW has also been examined on behalf of the charged official. Statement of PW2, Gurachand Samui of 3 signals so and so, PW4, Shravani Samui, as well as the prosecution exhibits 3 and 4. So he relies on 2 witnesses and 2 exhibits. 2 witnesses being the person who was allegedly assaulted and his wife. And exhibit number 3 and 4 have fully substantiated the charges leveled against the charged official by the disciplinary authority. Even during the cross-examination of the above 2 PWs, the charges have been stand-proved. I take it that their testimony could not have been shaken.
Yes.
PW 3, 4, 7, 8, 9, 10 in their statement have deposed that there have been injuries, marks on the face of the Constable GD Gurachand Samui on 3 signals so and so. DW1 Sunil Kumar Suman has deposed that he had witnessed Gurachand Samui manhandling the charged official. However, as evident from the statement of PWD's
the eyewitness.
Yes.
DW1. Yes.
Evident from the statement of PWD's and prosecution exhibit number so and so, Gurachand Samui was having injury marks in his face. As such, it is a fact that the charged official has indeed manhandled the constable and also abused him in front of his wife. Moreover, neither any of the PWs or DW have ever deposed noticing any injury marks in respect of the charged official, nor the charged official himself has produced any documents in this regard. This was not the defense case.
Yes.
But first and primarily, not the constable had an allotted place of duty or he was off duty at that relevant point of time. Was he supposed to go at the place of occurrence? That should have been the first approach of the authority. Then not other things. The first thing that is required to be gone into is, did I step beyond my authority? Did I leave my place of duty and committed negligence and had abused him and assaulted him? The other point is whether this gentleman who is complaining against me was at his place of duty during the occurrence of the incident. As per prosecution exhibits 3-4, bleeding from nose, mouth, redness of left eye in respect of Constable Samui is evident, which implies that Constable has been beaten by the charged official. DW1 Sunil Kumar Suman has deposed that he had witnessed Constable Gorachand Samui manhandling the charged official. However, as evident from the statement of PWs 2, 3, 4, 7, 8, 9, 10 and prosecution exhibits 3-4, Samui was having injury marks in his face. As such, it is a fact that the charge official has indeed manhandled the constable and also abused him in front of his wife. Moreover, neither any of the PWs or DW have ever deposed noticing any injury marks. Paragraph 5. In view of the facts enumerated above, the undersigned is in full agreement with the findings of the inquiry officer, in which he has rightly held the charges framed against the official at Article 1 as proved. However, keeping natural justice in view, a copy of report of inquiry officer was served to the charged official vide this office letter of 16th June 21 with direction to submit his representation, if any, against the said report within 15 days. In response, the charged official has submitted his representation on 17th July, received through Commandant so-and-so on 20th July. The representation of the charged official has been examined by the undersigned, and it is observed that he has not put forth any cogent or fresh substantive evidence in his defense other than that he has already produced during the course of inquiry, which warrants any interference with regard to the charges framed against him. The charged official has merely submitted about biasness by the EO, which was already attended to by the disciplinary authority at the time of personal hearing of charged official. The further submission of the charged official that Constable Samui was in the state of intoxication and started abusing him as well as blow fist upon him are not acceptable, as it has not been corroborated with the statement of PWs or prosecution witness exhibits, and lone defense witness supporting his contention is also facing the DA proceedings in the instant case and cannot be treated as credible witness. Apart from these, so why apply different tests? If one is facing a different disciplinary proceeding and his witness is not credible, evidence is not credible, so why believe the other? Apply a uniform standard. Apart from these, charged official never submitted any medical examination report or complaint supporting his aforesaid. How could I? But these are considerations which don't appeal to a logic of general standard. If the charged official was ever manhandled by the said constable, then he would have undergone medical examination to prove the same. But please visualize the situation. It was not my case that I suffered an injury. I said that gentleman had come, abused and tried. The other person had said that had tried to assault me. There was a scuffle. I might not have sustained an injury which is worthy of a treatment.
Yes.
If the charged official was ever manhandled by the constable, then he would have undergone medical examination to prove the same. It is also evident that PW2, Gorachand Samui of so-and-so, Srimati Shravani Samui had lodged complaint vide their application dated 4/3/2020 before the commandant, leveling allegation about using of unparliamentary language as well as manhandling by the charged official. On the contrary, the charged official vide his application dated 17th March 2020 had leveled counter allegations against the above constable. As the charged official was performing duty of SI adjutant, he was supposed to submit a report of the incident immediately to the appropriate authority, but he did not do so and submitted an application on 17/3/20. That is after lapse of more than 15 days of incident, which clearly indicate that it was afterthought just to dilute his misdeeds. As such, there is no iota of truth in the submission of the charged official, and it is a counter allegation. It is also pertinent to mention here that on the basis of complaint submitted by the charged official against constable, that the said constable raised his hands to beat the charged official, which resulted into the incident of fighting, a DE was ordered against Constable Samui. Please take note of this sentence. So that first, the defense witness is disbelieved because a disciplinary proceeding was pending against him, maybe in relation to some other incident. Here, a disciplinary action was initiated against the complainant, but his statement is accepted. But who could be a more interested witness than him? However, the said charge or allegation could not be proved during the course of DE, and hence Constable Samui has been exonerated from the charge and the DE has been dropped by the disciplinary authority by Commandant so and so. The charged official has indeed committed grave misconduct in which he has used unparliamentary language as well as manhandled the constable and has acted in a grossly inappropriate manner and committed a grave misconduct. The charged official has also acted in a irresponsible manner in which he has adopted dilatory tactics to delay the inquiry by leveling false or vague allegations from time to time against the EO, and at times refused to sign in the statement of witnesses and tried to delay the departmental proceedings to the maximum, and even denied to receive the copy of the same in spite of repeated direction by the discipline authority to participate in the DE properly. It is pertinent to mention here that as per Chapter 3 of Officers Manual, the rank of subordinate officers carries special responsibility as well as privilege in dealing with subordinates. He must be strictly impartial and above any prejudice. Combining firmness with sympathy, he should be ready to give patient hearing to any problems of his subordinate and bring any genuine grievance to the notice of his superiors for redressal. Above all, he must always be standing example to his subordinates. The charged official is a subordinate official and he was performing duty of sub-inspector, which is very important post in any battalion and carries a lot of responsibilities. He is expected to be very disciplined and upright in this act, whereas charged official miserably failed not only in his duty, but also acted in an irrational and highly indisciplined manner. Though the charged official is not a fit person to be retained in his elite force, however, keeping his length of service as well as family responsibility in view, the undersigned, after considering all the pros and cons of the case, has taken a lenient view and accordingly, in accordance with the powers conferred on the so and so, imposes the following order. Punishment of compulsory retirement with full pensionary benefits and gratuity under provisions of Rule 40 from the date of issue of this order. Under the provisions of Rule 28, he has a right of preferring able. So, how does it change? He says that he is not entitled to be retained in service. He is not retained in service, as if it was operating as a mitigating factor. This paragraph 7 begins with the impression that although he is not required to be retained in service, but the employer is taking a lenient view. But the end result is he is not retained in service.
This is not the order of dismissal has not been passed.
Retained
Compulsory retirement so that you get the benefit.
This is
so that is the leniency according to the discipline.
It is issued through the pen of DIG.
Yes.
Now, not if responsibility in office is
so cannot be retained further. So there are two ways: one to dismiss you, and another to.
Had I been removed, I would have got these benefits probably.
Removal also. Removal is also another form of penalty. Dismissal, removal, and compulsory retirement. So, what is the difference between compulsory retirement and removal so far as the benefits are concerned?
Normally, in compulsory retirement, this has of course come after various efforts and deliberation through the various departments of the central government. In compulsory retirement, pension is released.
Pension is released.
In certain departments, or not, this is of course a paramilitary force. In various departments of the government, even on removal, certain benefits are given.
Yes. So, what is the difference between this?
Removal may not. Removal operates as a bar to the same service.
Removal operates as a bar to the
same service. Suppose
same service.
I was SI.
Yes.
Had I been removed, now there is an advertisement issued for the for filling up the post of say constable.
I can apply. You could not have applied.
I can apply if I am removed.
If you are removed,
I cannot apply for the same post.
Oh.
Dismissal, I cannot enter.
Dismissal you cannot. But compulsory retirement also you cannot.
Also removed.
You cannot apply. So removal is a lesser penalty.
No, removal also entails termination, removal from the post, but the legal consequences.
Removal is of a higher degree of punishment
than compulsory retirement.
How can it be? But you say that compulsory retirement you cannot apply, but removal you can.
Compulsory is retirement.
Yes.
So I retire from the service compulsorily.
Yes.
This could be by way of a penalty. This could be by way of removal of deadwood.
It is a more harsh punishment than removal.
So yes, removal.
Though you are removed, but you can apply for a different post.
Different post. That's the consequence of it.
But compulsory retirement, you cannot apply for any post.
I am retired.
Yes.
Maybe certain benefits are forfeited. say gratuity may not be paid. I'll have to check up the CRPF rules.
No, here gratuity also given.
No, I'm not saying of compulsory retirement.
Compulsory retirement, gratuity also
Yes,
you are getting.
compulsory retirement.
Gratuity, pension, everything.
Compulsory retirement is not initially.
How much period you are left with?
Initially, on compulsory retirement, one was not paid any pension. But thereafter, the central government came up through deliberation that no, they should be getting pension and gratuity.
So you are entitled
get
to
pension.
pension.
He has been drawing.
Not I had
Been drawing pension.
I had 7 years of service
Since
left at the time of
2020.
dismiss. At the time of remove.
That's 7 years.
Yes.
He has been drawing pension.
28 would be my normal.
Mr. Majumdar is also not disputing. He says
Right.
you will be entitled to pension.
I would have superannuated in 2028. Now,
Yes.
please see the paradigm.
The appellate authority's order.
But please come to page 299.
$299.
My lords,
Tabular chart. Oh, these are the comments.
please come to the previous page.
Previous page 298.
Oh, probably it's 290. Please see the order at 299.
Yes, 299 is the order of the appellate authority.
Yes, that's the order.
So in a tabular chart,
Yes, yes, compared. Yes.
just compared. What is the comments? Then what
Whereas
is the-
records of the case, including DE proceedings, paragraph 4, called for and examined vis-a-vis appeal submitted by the appellant, the main grounds put forth by the appellant are discussed as under.
Yes.
But I leave aside the left column for the time being. Please come to the right-hand column.
Yes.
During the course of DE, charge of misconduct in which appellant has used unparliamentary language as well as manhandled Samui and has acted in a grossly inappropriate manner and committed a grave misconduct was proved. Please recollect not what was the charge in the charge sheet.
Yes.
As PWs and exhibits adduced in the DE proceedings. It is worth mentioning that statement of 10 PWs have been recorded in the subject DE by the EO and total 4 documents have been adduced in the DE as prosecution exhibits. Statement of PW2
Entirely quotation of the disciplinary authority's order.
principle is so. Not very. Please come to the next page. The first sentence is as per prosecution exhibit number so and so, reading notes, so and so. You held the charge framed as Article 1 as proved. Accordingly, he has been awarded the punishment of compulsory retirement from service. The said punishment commensurate to the gravity of offence committed by the appellant. Hence, contention of the appellant is not acceptable. Second, DE was conducted in fair manner and as per the laid down instructions on the subject, as per DE proceedings, charge official has not cooperated and intentionally delayed the DA. Hence, the contention of the appellant is baseless. Hence, it is denied. Third, once again, not
But
cooperative.
did not put your signature on the deposition.
There were 4 objections because statements were incorrectly being recorded. And twice I objected that why are you calling witnesses who are not named by the prosecution? But your is not desired to take the role of a prosecutor.
Order sheet also you did not sign. Maybe
That's on 2 occasions. Because I said that it is incorrectly recorded.
no order has been passed,
That-
not the deposition. Deposition you may
Daily order.
say
Daily order. Please come to that page.
it says that the refused to put his signature on order sheet. Statements I understand, but why on order sheet you refuse to put your signature?
Please come to that page once. Please come to page 160. 160 and 161. কিছু তো at least prompt করো, to know something.
But that cannot be a ground for proving that the charges being proved, because this is a totally different thing.
But this is a case of
You may argue that
this is
that conduct cannot lead to proving the charges.
This is a case of insubordination. My conduct in the inquiry in the presence of a superior officer, had he been present, this could be an act of insubordination.
Yes. So leading to a fresh charge.
But as in criminal trial, during the course of trial, if it is found that some other charge could be levied, then one has to input it in the charge sheet or frame the additional charges and give an opportunity of defense. That's probably section 216 of the erstwhile CRPC.
Yes. 160 you are referring to.
Yes, no, these were the complaints that I raised with regard to the nature and conduct of the inquiry. No, I am writing to the inquiry officer.
Yes,
That
this is with regard to recording your statement.
yes.
But the order sheet you did not also refuse to sign. There could not have any ground to refuse to sign the order sheet.
No order sheet in inquiry.
The
deposition.
the appellate authority records.
Probably he has mistaken this with the, I have not.
No, order sheet maybe that these evidences were heard, next date is such and such.
Deposition. This is
Order
deposition.
sheet, but the appellate authority records that kindly come to that.
So I will request
It
my
says,
I request my learned friend to produce any order sheet.
it says, page 300, refused to put his signature on order sheet and statements, etc.
Could be the daily proceeding.
Yes, yes.
Daily proceedings.
Daily
The
proceedings.
day-to-day proceedings, minutes.
No, not minutes. It's this is what is minuted, the proceedings. The inquiry assembles at 1 o'clock. These are the persons present. Then he records the evidence in, that's the proceeding.
Yes.
It's not an order sheet. No order sheet was there.
All right.
No, not when.
Appellate authority mostly proceeded on your conduct during the inquiry proceedings. First portion, he has only quoted the order of the disciplinary authority. The rest are your conduct during the inquiry proceedings.
Revealed from the records.
Revealed from the records, yes.
And it's not the conduct or demeanor of a witness that we have read as very important aspect of a trial. Not like that.
Last part is paragraph 5 is that principles of natural justice was followed.
That's common in every
that was
paraphrasing. That's paraphrasing.
Yes. Yes.
Now, just to show that not what was, please come to 2171. Now, this is part of my complaint lodged to the inquiry officer.
217.
These are my notes of defense.
Yes.
Or please,
according to you, this was not considered.
Please turn over to page 214.
214.
Yes, not. This is all not the accolades that he had earned during his lifetime. The chart from 1990 till 2019.
So, according to you, first is charges were not properly framed, even assuming that a portion of the charge was proved. The punishment inflicted is shockingly disproportionate. That would be your submission.
And please visualize this. It is nobody's case that the person who complained against me had unauthorizedly gone to that area. It was not his place of duty. It was a campus. Of course, it's a campus. Could be anybody's free zone. But I was performing my duty at a place, and this gentleman had gone to complain against somebody to me.
That is the reasoning of the disciplinary authority. You have a responsibility. You have to take care of that. You have to, once you have some complaints have been made to you, you have to try to get it settled. If not, to place it before the appropriate authority. That is your duty.
That
also,
is,
one of your duty you did not perform.
That is an expected conduct. That is an expected conduct, not a misconduct which can be derived from that. My failure to live up to an expected conduct may be my incapacity to hold a post.
Can it, or does it not amount to misconduct?
Misconduct is something positive which has to be proved. The first part is in the realm of assessment. Say, quite often we hear of
According to you, if a person does not fulfill the expectations, that does not amount to a misconduct.
Non-fulfillment of an expected quality is not misconduct. Suppose not a gentleman is promoted from stage 1 to stage 2. On probation, he is kept on promotion, he is kept on probation for a period of 1 year, 2 years, it is there. Now the authority finds that he is not fit to hold the promotional post or rank. He is stepped down. He doesn't lose employment. But I may not be
So according to you, a lesser punishment of reducing in rank could have been instead of, even if that is accepted.
I'm grateful, and more importantly, it's a wrong approach leading to perverse results.
Reduction in rank is also one of the
could have been penalties.
That is also one of the form of punishment. Yes. Anything more?
Why did your lordships not, while laying down the law time and again, why did your lordships have to point down that if one is found to be lacking, in competence during the course of his assessment, one has to be put on notice? Why? So that he gets a scope to improve. If this is a lack of quality, then he ought to be put on notice to improve. Certainly not a misconduct. And there the authority went wrong. Apart from everything else, charge completely different, finding completely different. In the entire finding of the disciplinary authority's order or the appellate authority's order, does your lordship ever find the mention of the word negligence? That's the main charge. So the finding is different from the charge, number one. Number two, application of a wrong test.
Yes. Yes.
Thirdly, my lord, both the authorities proceed entirely on the conduct of the writ petitioner during the course of inquiry.
That is the appellate authority.
Yes.
Yes.
And please come to page 294. But where I thumbed up not the.
What is 294?
294 is part of my statutory appeal.
Grounds of appeal.
Begins at 283.
Yes.
Not in the that
294.
Paragraph E.
That all the witnesses stated.
Yes, that they heard the same incident.
Hearsay evidence.
Apart from those two direct witnesses, the wife and the husband,
all are hearsay evidence. Yes.
Now please come to the injury report. Paragraph 9. So for injury over the eyes, nose and lips of Constable Samui and bleeding, it appears
Paragraph?
Page 294, paragraph
Yes, yes,
IX.
yes.
9. It appears from the medical report that the doctor who treated clearly stated in his medical report that no bleeding.
So that is here, the report is here.
Report exhibit 3, page 180. Bleeding from nose and mouth.
Yes.
Huh?
So there was
Now-
bleeding.
That is the complaint at the top.
Yes.
Please see the finding. No active,
No active bleeding.
complaint of bleeding from nose
So
and
what is
mouth
the meaning of active bleeding? It says
could not be
active.
seen.
It could have been internal. Something
Internal. That's not the finding or report.
No, this has to be after conducting some X-ray or something.
1/3/2020.
Yes. Some X-ray and other things were
Yes,
directed.
177.
After considering that, where is the medical report?
Please come to 177.
177.
Now please see the X-ray report form, the second column
Yes.
of that page. Some zymalized bones show no obvious abnormality.
Suggested further evaluation if
Sila appears normal.
Clinically-
Suggested further evaluation if clinically indicated.
thereafter nothing. This is the only medical.
Exhibits 3 and 4.
So according to you, though there was some injury, but it is not that serious.
Whatever, it is my duty in the appeal proceedings to say that this is available on record. Now, exhibits 3 and 4 are heavily relied upon to say that he sustained a gross injury. Now, please see paragraph B. No, I'm sorry, paragraph A. That the medical officer was not examined, that the medical officer asked for X-ray and in X-ray report, nothing adverse report was shown. That out of altogether 9 witnesses except Constable Samui and his wife, no one stated that they have seen that myself blow fist upon him,
No,
and all are heard from other sources.
Mr. Majumdar, why the medical officer is required to be examined? Not in all cases. If you dispute, if you say yes, there may be a necessity, but in all matters, is it necessary that medical officers are to be examined if you do not dispute?
To what extent the injury was suffered, or that I don't say that he was not examined by the medical officer.
You have also not disputed the nature of, you are on the other hand, you are relying on the medical report to show that nothing that serious occurred.
So
something has done. You are not denying that this was not.
So whatever is there in the report, nothing can be traversed beyond that.
Yes.
In the absence
So in
of
that event, whether the medical officer was
So
required
in
to be
the
examined.
absence of medical officer's examination in the inquiry proceeding, whatever material is produced in relation to the medical examination stands.
Yes.
These are the two findings. He could have come and explained by reason of this injury at such and such place, it could have resulted in this sort of a situation. That's not there. That out of altogether 9 witnesses except Constable Samui and his wife, no one stated that they have seen that myself blow fist upon him, and all are heard from other sources, which was propaganda by both, that is Constable Goras Samui and his wife. Alternatively, Samui admitted that he was too much angry regarding behavior with his wife by Sunil Kumar Shuman, and he blow fist upon me, but I was saved. Similarly, his wife also admitted.
This Goracha Samui admitted that he blowed fist.
Page.
That similarly, his wife also admitted such fact.
Please, I just show that particular.
Show me that admission.
Page 84.
Page 84 is the admission.
No, I'm sorry, it's page. Hey, page number 84. Left hand bottom is the name of the witness, Srimati Shravani Samui.
Yes, yes.
Commander asked my husband whether he laid his hand on SI Ray, Sub Inspector Ray, Operative Sushant Kumar Bokshi. My husband said that he laid his hand for his defense.
It should be laid.
Should be laid. You know, what can be
Yes.
done? To decipher from.
All these are official translations.
But the left hand side is the initial with the number.
Yes.
For his defense and for assaulting him because 4 Jawans had caught hold of him. Then the wife of the commandant told that Sunil Kumar Suman had misbehaved with you, did not give in writing, or there is need to give in proof, and you have told me which is sufficient, but commandant said to give the complaint in writing. Laid his hand. He says, but in defense. And please see the evidence of that Samui.
No, what is the meaning of this? Said he laid his hand for his defense and for assaulting him.
Yes.
What is the meaning of
Both.
that?
In a scuffle, there can be assault, there can be defense.
This was the wife's admission.
Wife's statement.
Yes.
And not the statement. I also show not the statement of the complainant. अरे भाई relevant portion to पढ़ ले बोलो पढ़ो निकाले छोड़ huh?
Yes.
Please come to 64.
64. Yes. Mr. Majumdar, how long you will take?
It's almost completed.
Because there is a bench at 3. That is the difficult.
And then
How much time you will take?
but another 15 minutes maybe. I cite 2 judgments and just read this portion and that I conclude thereafter.
All right. So tomorrow may not be, I do not know. So there is another.
So, 2 things, that there was a scuffle and that gentleman had approached me. This is evident.
Heard Mr. Majumdar, learned advocate for the petitioner. For further argument of Mr. Majumdar, list this matter tomorrow under the same heading.
Tomorrow I have difficulty.
You have problem?
Yes, not.
Monday kore din.
বলা বাকি আছে হয়ে গেল।
Item number 1, 2, 3.
Reference. What is the reference?
Vastu. in a preemption proceedings.
Vastu, that was decided.
Last occasion, my lord, what happened, my lord, in this case, that
You are in which item?
one.
Petitioner.
But I am the opposite party in item 2. I am led by Mr. Obrotosh Majumdar.
You are opposite party in item number 2.
2.
Who is for the petitioner?
Mr. Aniruddha Chatterjee.
All right. And
3. Item
Mr. Rai, who is your other side?
One other seat.
You do not have any other side. And item number 3, who is appearing for whom?
I'm sorry.
Oh, Mr. Mukherjee, Devjit Mukherjee.
Is your opponent?
But I'm sorry, in item 3, I am for the opposite party and Mr. Aniruddha Chatterjee is for the petition.
So item number 2,
In item number 2, I am for the petition.
you are for the petitioner. And who is for the opposite party? Written notes of argument filed. Yes, Mr. Rai.
Okay. আমি কেন বলবো?
You are for the petitioner.
Item number 1.
Yes.
Other side is.
He's the petitioner.
So if you are Mukherjee, your other side is here. He is opposing you.
No, I'm the team.
Mr. Rai, if you are for the petitioner, why are this side? Go to that side.
এদিকেই বলবে petitioner.
Go to that side at least.
Point of reference.
আমাদের আইটেম নম্বর কত রে?
He will act as an amicus.
ব্যাস পার্থ তোকে বলেছেন।
Lord, I appear on behalf of
What is the point of reference?
Where is the point of reference?
Yes.
Lord, I beg to appear, my lord, on behalf of the petition in item number 3. But for some reason, Lord, my video has been stopped by your lordship's
You
officer.
are audible, Mr. Chatterjee.
Lord, kindly direct your officer to, my lord, open my video. They've stopped my video.
ঠিক করেছে।
এই ভিডিওটা অফ হয়ে গেছে বলছি।
এখন মাফি বলবে।
হ্যাঁ।
সেটা বল। কি করতে লেগেছে?
Mr. Chatterjee, fault from your end.
No, they said that the host has stopped it.
Oh, Mr.
Host
Chatterjee
is my lord's officer.
পার্থ তুই বলিস না, তোর নাম সিনিয়র।
Yes, yes, all right. So you are audible. That will, for the timing, that will serve.
Other things I can assist him because he's a senior advocate. My lord, he should address first.
Certainly not. The state was addressed.
Mr. Chatterjee is for the petitioner.
Yes, in item 3.
Let him out. I will adopt this.
আমার আর্গুমেন্টের কথা না, they were arguing, Mr. Chakraborty, Mr. Majumdar was arguing, my lord, on before Justice Orijit Banerjee and finished his submissions. So he has
Now,
to
Mr. Chatterjee, it has to be hard afresh.
So he needs to start first, not us, because he is saying, my lord, Vastu is, my lord, preemptible.
No, they are saying it's not, and that's why they had preferred a revision and they have got an order. So they are for the petitioner.
Mr. Gupta, why are you saying something different? It was all along that Mr. Majumdar was submitting first. Why are you saying something different?
All right, Mr. Rai says he will start first.
Very well.
Yes,
Chatterjee is there, my lord.
Where is the reference?
Yes,
Lord, 1, 2, and 3. I'm 3.
রেফারেন্সে অর্ডারটা জজ সাহেব ফাইলে আছে।
My lord, there was an order on the state as well to appear.
Who is for the state? Who was appearing for the state?
Mr. Tale.
Mr. Tale.
And my lord, even the learned advocate general was asked, requested to appear because of a point of section 1A of the Land Reforms Act.
Which order?
Lord, Justice Banerjee's order, my lord, that last.
Last যেটা রেফারেন্স হয়েছিল।
রেফারেন্সটা এখানে
ট্যাগ হয়েছিল।
রেফারেন্স জজ সাহেব ফাইলে পেয়ে যাবেন।
ফাইলে আছে।
Does not conclude.
Mr. Chatterjee, do you have the date of the order by which the learned advocate general was requested to appear?
Kindly have a look at 4th of May 23.
4th of May.
ঠিক আছে, ঠিক আছে।
আমি অপোজ সাপোর্ট কিছু করছে যেদিকে হবে সেদিকে গাইলেই
Of May
মানে কাইন্ডলি সি মানে
does not
26
record that. 4th
26
of May says Mr. Mojumdar, our senior advocate representing the opposite party, resumes his argument but does not conclude.
26 September kindly see once.
26 September.
September 2023. The issue that we have to decide is whether or not the right of preemption under section 8 of the West Bengal.
Give us a second, give us a second.
No, Mr. Rai is there. He should be having all the orders with him. Mr. Devobroto Rai, not Mr. Bhattapati Rai.
26/9 কোথায় দেখতে পাচ্ছি? 26/9
available in respect of, yes, 26th of September
2023.
23. The issue that we have to decide is whether or not the right of preemption under section 8 will be available in respect of a Bastu land.
That's the point of reference.
Accordingly, we request Mr. Such and such. Oh, Mr. Siddiqui was requested to convey the.
Yes, yes.
Then what can be done? Anyone for the state? Where is Mr. Siddiqui? Mr. Mukherjee, can you ask your junior to call Mr. Siddiqui?
Because Mr. Siddiqui had come and informed Justice Banerjee's, Honorable Justice Banerjee's division bench, Lord, that he adopts whatever Lord, Mr. Mojumdar has submitted.
Mr. Mojumdar has.
Mr. Mojumdar is leading you.
In item 3 for the.
Where is he? All right, Mr. Rai, you can start.
Mr. Chatterjee.
Start.
কি হলো?
Yes.
কি স্টার্ট করব? এই করে শুরু করে দিলে হবে নাকি?
No, Mr. Mojumdar was making a submission. Why Mr. Rai and I, my lord, we will be making submissions that Bastu preemption doesn't lie. Mr. Mojumdar has started making submissions and has submitted, my lord, completely on, my lord, why there will be, my lord, Bastu on, my lord, there will be preemption on Bastu. He submitted it. Why change it?
That this bench will sit at 3 p.m. It was notified earlier. You have to start then.
My lord, we were under the impression, my lord, that since ours is the last item, the others will start, and so, my lord, if your lordship could.
No, it was not like that. Mr. Gupta is not correct.
To decide amongst yourself.
My lord, we will start. My lord,
when to start, then we will fix accordingly.
We will then start. My lord,
start. You start, ask Mr. Mojumdar to come.
But there are at least 30-35 authorities which we had relied upon. My lord, right from the first. So, my lord, kindly does not take it up today. Any other day your lordship will keep. We shall start the arguments and continue. But the only difficulty
to fix this matter. On that day also,
your lordship will indicate that in the order. But we were under a different impression, and your lordship will kindly not take us amiss. I'll tell you, lordship, why. After hearing for 20 days,
prior to the vacation, the date was fixed long back.
But I understand this matter was heard for 20 days. Thereafter, this was.
We can release.
No. Kindly does not do so. We shall do it. But for today's date, my lord, your lordship, because we were under a different impression, but possibly wrongly.
What was your impression?
That
you expressed that before.
That
what was your impression?
That the other petitioners are there in the other matters, and their arguments would take a substantial time. So, my lord, Mr. Mojumdar, we had a word with him. He said, "Let the others submit. The day I'll continue."
He was the only one who submitted. The others never submitted anything.
Preemption is not maintainable on Bastu.
Yes, maintainable on Bastu.
Is maintainable on Bastu.
Maintainable.
Is maintainable.
Because definition of land includes homestead land also. So this includes.
All right. Yes, Mr. Rai, you start.
No, 35 judgments were cited by him. He started his submission.
Mr. Chatterjee, let us start somewhere, because today we are starting afresh.
They started all this while. Suddenly,
Mr. Chatterjee, they are not available today. Then it has to be adjourned. We do not know.
Some other day, let them start. It's easier for us to answer. It's basically, we have to defend that. We are not on the
Chatterjee, you are before a new court.
That's why, that's exactly why. Mr. Mojumdar is here.
Starting.
And petitioner
Mr. Mojumdar is here.
Start. Yes, Mr. Rai, you start.
My lord, I appear for the petitioner in one of the matters, my lord, subject to whatever.
Amar video on আছে, video
Yes,
off.
Mr. Majumdar, you
Yes,
are
my
petitions that
yes,
is
my lord.
petition given to us by Mr. Chatterjee.
Yes.
So start.
But the matter right now, my lord.
Yes.
Just one. Give me 1 second, my lord. Give me 1 second.
My lord, he has liquid text. He will bring out everything right now.
Madam, my video has been disabled. I don't know why.
Exactly. Even mine. Even
My
mine.
video has been disabled.
Mr. Majumdar, you are audible.
Yes,
But
kindly
my
give
lord's
me a second.
officer, my lord, kindly directs them to my lord open our
Start
Madam, may I just indicate to your lordship what are the issues involved, my lord?
Yes.
Madam, the issues involved would be first, madam, the referral order we have to place before your lordship.
Yes, that was placed.
That has been placed. Then I will take your lordship to the analysis of the relevant provisions of WBLR Act, WBNAT Act, WBEA Act, and my lord, the ALCRA. Then, my lord, a point was thought to be taken by Mr. Chatterjee regarding the impact of, my lord, WBLR Amendment Act 1981, WBLR Third Amendment Act 1986, and WBLR Act 2000. Then another question which arose, my lord, we had a prolonged hearing, my lord. So, my lord, I'm just formulating the issues for your lordship's kind consideration. This next issue which arose is that whether WBLR Act is applicable to vacant land in urban agglomeration under ALCRA, that is Urban Land Ceiling Act. Then, my lord, the effect of commencement of WBLR Amendment Act 1981 and the operation of the West Bengal Non-Agricultural Tenancy Act 1949. Then, my lord, the next issue would be whether right of preemption, which is the essential issue before your lordship, right of preemption under Section 8 of WBLR Act could be exercised in respect of Bastu land in municipal areas. Then, my lord, the scope of reference, my lord, it was my submission before the Honorable Division Bench that the other issues which are now sought to be raised by Mr. Chatterjee are issues which are not germane for consideration because, my lord, this court would confine itself to the scope of reference only, the reference only.
Yes.
For that, and then, my lord, the consistent view taken by the court, barring a few exceptions, and then I will, my lord, summarize. My lord, may I just take your lordship to first the analysis of the relevant provisions of the WBEA Act, WBLR Act, WBNAT Act, and ALCRA. First, I take your lordship to the impact of the WBLR Act, LR Amendment Act 1981.
Just a minute.
I'm sorry.
Let us start.
Yes, my lord.
Yes.
Yes.
Then may I continue, my lord?
Yes. Now you are visible.
Now I am visible, my lord. My lord, actually, my lord, we are not that good looking. So, my lord, whether we are visible or not visible doesn't matter much.
Who are the honorable judges?
Very much wanted that
Mr. Majumdar, my lord, is speaking for himself.
Yes, I am speaking for myself. Absolutely. Mr. Chatterjee is there, such a handsome looking man. Then Mr. Rai is also there, I find.
Mr. Gupta, and why are you forgetting Mr. Mukherjee? Mr. Majumdar, you must Mr. Mukherjee is there.
Mr. Mukherjee is there.
Devjit Mukherjee.
Oh, Devjit Mukherjee is there. Then, my lord, should we start today even?
What do you want?
My lord, kindly give us a date. Kindly give us a date, my lord. We are ready with the matter. We want to do it physically, my lord. I tell your lordship what, my lord, actually, I thought, my lord, your lordship would be fixing a date for hearing. So, my lord, today I have the notes ready.
So has not informed you. This date was fixed for hearing long back.
I'm sorry, my lord. It is
Just
it is
before
my
the
then,
application,
my lord, it is my fault.
State, date and
Then it is my
chronology.
fault, my lord. I will not say anything. Then it is entirely my fault. I take it upon myself. This is my fault. My lord,
Not
kindly
your
give
fault.
us a date. We'll come and do the matter with your lordship.
Mr. Gupta did not inform you.
Mr.
Mr.
Gupta.
Gupta is
No,
now
my lord.
driving around
My
in
lord,
big, big
I
cars,
have a
but he's
certain
forgetting
bias
to
in favor of Mr. Gupta, so I cannot say anything against Mr. Gupta.
No, I have no bias. I can say, my lord, he's buying, my lord, big cars, my lord, he's forgetting to inform on the phone.
Yes. That's true. That's true. That I agree. Here, my lord, the opposing parties, my lord, are addendum.
Mr. Majumdar, how long you will take?
My lord, it will take some time. It will take some
How
time.
long?
My lord, perhaps, my lord, we require, I require at least, my lord, 2 to 3 hours.
My lord, he took 10 days on the last honorable division bench.
3 hours.
But now I don't want to do that with Mr. Chatterjee around, but it's very difficult. And I tell your lordship, my lord, presence of state would be necessary because Mr. Chatterjee took that point on the last occasion. In fact, my lord, the hearing got adjourned because we could not get hold of the learned advocate general, Mr. Dotto, my lord. We know, my lord, he was suffering at that point of time.
Mr. Majumdar, we can request the learned advocate general.
Well, I tell your lordship, there is a development. I have been told by Mr. Siddiqui.
State is not a party.
State
Not
is
a party.
not a
But
party
there
as
is an order. But there is an order.
Mr. Siddiqui perhaps is now
Order.
appearing in the matter.
There's an order requesting Mr. Siddiqui to inform.
Right. So,
that is a different thing.
So, kindly keep it in the reopening week. We will do the matter whole hog.
Reopening week.
Yes,
so
madam.
lastly, it was before the puja vacation.
No, reopening we will do. My lord, I will absolutely do the matter because my lord, my client is suffering an interim order.
Mr. Majumdar, it was because my lords were not available. That is why we could not continue.
Yes.
We were always
But
available.
today all these submissions we will make, Mr. Chatterjee and I. We are absolutely at item because we are both online today.
We got to the learned advocate general. Said your junior contacted Mr. Siddiqui.
অবরোধ একবার কিশোর দাকে ফোন করো না দেখো না কি
Malad, may I just Malad, I believe Malad, Mr. Siddiqui has been assigned by the state or by the learned advocate general to appear in this matter. Lordship will give me kindly 1 second, Malad. May I try to get hold of Malad, either Mr. Siddiqui or Malad, I'm muting myself.
Yes.
So the subject to question, Mr. Siddiqui on the earlier occasion said that the state has no different stand in respect of the matter. Whatever the decision of the court, they will abide. They are not specific.
Right, he was to answer the 1A point. He did
1A
not
point
answer
only.
that.
That is why the state has said that we do not have any special attention so far. This
No, they've got to bring the records with respect to 1A.
Because there was an order passed by Honorable Division Bench, wherein the Honorable Division Bench felt that the learned
Presence was required.
Malad, I could not get hold of Mr. Siddiqui. Malad, kindly post it. Malad, I will inform. Malad, both of us will inform. Malad, no problem. We will do that.
So you're the petitioner in the third matter.
I am in Sukumar Set, I believe. I am in Sukumar Set. I think Mr. Chatterjee is opposing me in my matter, I think.
Mr. Chatterjee's petition, we are opposing. We are for the opposition.
We are opposing. I'm sorry.
You are always opposing.
Yes. So, kindly give us a date, my lord. We will get back. We will obviously do the matter.
Which order you referred? Order dated?
September.
26 September, my lord.
26 September.
2023.
এই সেকেন্ড ফাইলে সব অর্ডারগুলো রাখবেন। সুযোগ থেকে ফাইলে সব অর্ডারগুলো রাখবেন।
23 my lord.
অসুবিধা হয় না, এরকম ভাবে করে দেখতে হবে।
But I have handed over a photocopy of
That
the
is
order.
the order of
Yes.
reference.
Oh, yes.
In which order the learned advocate general was requested to appear? Oh yes, we have.
Hardi matter.
I just spoke to Mr. Siddiqui. But today he has left the court for some personal reason, my lord.
Who? Mr. Siddiqui?
Mr. Siddiqui.
Yes. Reference will be made to the order dated April 10, 2024, wherein the Honorable Division Bench requested Mr. Siddiqui, who usually represents the state, to convey the request of the Honorable Division Bench to the learned advocate general to assist the bench in the matter. First up, paragraph. Mr. Mojumdar, learned advocate, appearing for the opposite party.
Yes, my
In
lord.
item number 3.
Item 3, my lord.
715 of 2020.
Item number 3 টা CO নাম্বারটা করে দেবেন।
715 of 2021.
A brief outline of the issues involved.
Yes, my lord.
This matter. Mr. Mojumdar prays that this matter be taken up immediately after reopening of this court after Xmas vacation. As prayed for by the learned advocates, as jointly prayed for by the learned advocates for the parties, list this matter after reopening of this court after Xmas vacation. Date, it's difficult to fix now. It will be intimated 1 or 2 days prior to the date of
Just a weekend, my lord, before your lordship sits. A weekend.
A week, my lord. So that, my lord, your lordship, my lord, we
what
would
will
not.
happen after that? Fixing a date. What the present is.
Maybe, my lord, maybe, my lord, Thursday may be a convenient day.
Yes.
Maybe, my lord, I subject to your, leave it to your
Yeah,
lordship.
we will fix. It will be intimated in the list 1 or 2 days in advance.
Because, my lord, we don't want to disrupt the business of the honorable court. My lord, we want to leave the matter.
Intimate the learned advocate general.
Yes, my lord, that we will do.
The order dated April 10.
I think Mr. Rai is sufficient.
Of April 10, 2024, as well as this order.
Mr. Rai can be appointed as an amicus curiae, my lord. He can argue for both sides.
Yes, my lord, that he can do.
Both you and Mr. Rai as amicus.
Yes, my lord, that will be very good. I'm confident Mr. Chatterjee will make submissions in favor of my client.
Take the responsibility.
When appointed as amicus.
Yes.
Grateful, my lord, grateful.
Grateful.